Okay, I think we're just about ready to get started. Let me see how many people we have here. We're still missing a couple people, so I guess I'll wait a minute or two. I think I'm expecting 30 some odd people. So I guess I'll give it a couple more minutes. Okay, well, it is 8 o'clock, so I think we're gonna get started. Well, welcome to the third of what are going to be 4 this season of our AAIP live stream webinars. We have a great lineup today, great information for everybody. And I hope everybody will bear with me in these first few minutes as I'm speaking. I'll also be admitting people into the lobby, as always the case. Anyway, so today we have 3 speakers. Our first speaker today is going to be attorney Nick Strom. And I'm going to let Nick introduce himself in a moment, but as soon as I go through just some housekeeping things before he gets started. The seminar topics today include business entities. So you'll learn about business formation, operating agreements, bylaws, shareholder agreements, business succession plans, employment versus independent contractor agreements, business purchase and sale agreements, and piercing the corporate veil. So he's got a lot of different business related issues that he's going to go over. The next presentation will be, or the following presentation after that one will be e-filing in Arizona courts, presented by Kelly DiCarlo. And I'm real interested to hear that one. That's an ever-changing environment, particularly, well, for everybody that works in the court system, in the legal system, but particularly, I think, for us. But we'll get into that more when Kelly is speaking. And then I will be doing a presentation on alternative dispute resolution and family court conferences. And as I'll talk about more at that time, the presentation will be focused more on conciliation services, but we'll learn about mediations, open negotiations, talk about parenting conferences, and then also some various community resources that you can maybe refer your clients to reduce high conflict and deal with other issues that litigants and family law are dealing with. And then I will also be weaving in different ethical topics throughout the morning. I think following the various presentations and wrapping that up at the end of the day. As you're all aware, this is a 5-hour conference. We're starting right now. We'll be ending probably just after 1 o'clock or right around 1 o'clock. Few other issues that we want to go over, just remind everybody and tell everybody that has not attended one of our webinars before that we certainly welcome participation. I will do my best to facilitate that. If anybody has questions or comments, there are 2 ways that you can make that. One way is to simply raise your hand. And as many of you are probably aware, at the top of your screen, or sometimes if you have a Mac, it's kind of in the middle of your screen for some reason. I think the software is a little bit different for Macs or other computers, but you can raise your hand. Like I'm raising my hand right now. People might be able to see that, and then and I will keep my eye on that, and I'll ask Nick and Kelly when they're presenting to kind of keep their eye out for anybody that has a question. or you can also use the chat feature in Teams to make a comment, ask a question. But again, we encourage your participation. So I love these webinars for many reasons. One thing I'm not so crazy about, and this is just because of my style of teaching, of presenting, I like I think it stifles to some extent the participation that I'm used to when we do these live. And so I've been trying to think of different ways that I can encourage people to raise your hand, or just, I guess we can't just speak out in this environment, but please, bottom line is that please feel welcome to participate and ask questions and make comments as we go through each of the presentations. Very important thing to mention, to remind everybody, is how you get your certificate of completion. So throughout the day, at various times, I will at three times today, I will raise what I refer to as a verification word. And it's just a random word that I've thought of. And you want to make sure you write down that word. Again, there will be three of them. I will hold it up to the camera. I'll speak it. I'll spell it. And just make sure you write down those three words. And at the end of the conference, email me those three words. You can email me just the way I emailed you the notices. You can respond to those if you want. However you do that, but in what I have sent each of you has the email address to send it to. But send me those three words, and I will respond with your certificate of completion for today, as well as any handouts that that the presenters provide to me to give to all of you. So again, really important that you pay attention and make sure you write down those words in order for me to provide you with the verification, or with the certificate of completion. So I think that's all the housekeeping stuff I have to go over. And so in order to get the first presentation going, let me, Nick, I need to find you on my list here so I can spotlight you.
Sure.
And then we will get going with that. Here we are. Okay. All right. So with all that said, I'm pleased to introduce Nick Strom, attorney Nick Strom. Nick is going to talk about business entities. And Nick, I'll hand it over to you to say a little bit about your background, your firm, all those fun things. But go ahead and take it away.
Sure. Well, first of all, thank you so much for having me, everyone. I'm really excited to be able to present here today. My name's Nick Strom. I'm with a law firm, Fowler St. Clair, in the Scottsdale area. We're actually celebrating our 10th year of being around this year, so we're very excited about that. Our primary focuses are business law, real estate, civil litigation, and estate planning. A little about me personally. I'm from South Bend, Indiana originally, went to Notre Dame, go Irish. The Lady Irish start here in about 20 minutes. So hopefully they can win in the Sweet 16 here. I lived in Chicago for 9 years and then moved here about a year and a half ago, July 2020. So today I'm going to be presenting on, everything you need to know about business planning. This is going to be a 30,000-foot view. The topics I'm going to talk about today, you could have semester or maybe year-long courses on each of them. But I think we're going to set good basics, good foundation, and I think you'll learn something here today. So let me try and share my PowerPoint presentation. Got to move this. And can you guys see the PowerPoint?
Yes.
Okay, excellent. All right. So like I said, this is everything you need to know about business planning. And let's take it away. A little bit about me. Again, my firm is Fowler St. Clair. My primary focus is kind of the business law, real estate litigation. But the most interesting thing about me is actually that I'm the proud father of 5-year-old quadruplets. They're listed here. We have Jack on the far left, next to Charlotte, next to Declan, and next to May. Yes, I am one of those dads who takes absolutely every opportunity to talk about my kids, and they will pop up here from time to time throughout this presentation. Okay, so moving on to the next slide here. So I'm going to just talk about the common business entities you'll typically see. My goal here is to provide a solid background on business planning. We'll go through some basics. I'll give some foundation for what you need to know about this area. And if you take nothing else away from this presentation, I'd like you to just remember that the main purpose or focus of forming an entity, going through all that legwork, all that cost, to form the entity is to reduce exposure for the individuals involved in the business, protecting your own personal assets, things like that. One big takeaway, it's just so crucial to follow the rules set by statute, and then the buzz phrase, follow the corporate formalities. We'll get into more detail on that as we go. But those are, the crucial things to remember when forming a business entity. So here we have listed the common business entities that you'll come across. The first two, the sole proprietorship and the partnership, these are default entities. This is kind of a situation where you start working and the state, wants to define everything, every aspect. So if you don't, fill out documents and register with the state and whatnot, you're going to fall into one of these two categories generally. A sole proprietorship is just what you would think. It's an individual doing work by themselves. A partnership is, when two people are doing work together. And the basic key here for a partnership is you're splitting profits. I'm sure you can imagine a business, maybe a lawn care service, where there's the owner and there are people working for the owner, but they're not sharing profits. So it's unlikely going to be a partnership. And we'll get into issues of whether it's an employment agreement or whether it's an independent contractor as we go through this. Now, the latter three entities I have listed here, the limited partnership, limited liability company, and corporation. Now, these are generally going to require following the business formalities, filing appropriate documents with state, filing the appropriate fees. We'll get into more details of that later. Those latter three is where some more legwork comes in, where you can provide some real value to your clients. And as you can see, I have the statutory sites there listed. Okay, so our next step here is to talk about formation. We're going to go over, how these entities are formed. One thing I want to stress, and I take the time to stress this whenever I'm presenting on any aspect of what I do, I just want to highlight how important it is to always refer back to the statute or the rule or the case law, no matter how many times you've done it. I think, as legal professionals, we all know laws are constantly, they're evolving, things change. Putting in that legwork on the front end really helps, maybe you'll find a good form or something you didn't notice the first time. I've had mentors who practiced for 40, 50 years, and they still refer back to the statute. So that's just something I always like to take the opportunity to highlight. Okay. Sole proprietorships and partnerships. Like I said before, these are going to be the quote unquote default entities if you just start doing work. Like I said, a lawn service business, even, some kid going door to door, mowing lawns throughout the neighborhood, be, kind of more the sole proprietor. And then maybe if you have two kids going around the neighborhood mowing lawns and splitting profits, that would be the partnership. Again, sharing profits is the major issue with partnerships, the major distinguishing factor. It's different than just, hiring other lawn care help. Now, the important thing with the sole proprietorship and the partnership to remember is, sure, it's easy to form. You don't have to go through, the hoops of filing with the state or the costs, but you are personally liable for debts and obligations of the business. It's, again, one of the keys here to forming a business entity is to protect your personal assets. And you could see something going wrong on the job, or, COVID slowed down businesses. You still have debts, you still have to pay, for your car payment if you're an Uber driver, your lawnmowers if you're the lawn care guy, and you're on the hook for those debts in these entities. So it's an important thing to remember and let people know. One subject I kind of want to throw in here is, it's a little off topic, but the utility of an umbrella insurance policy. This is you may know, a policy over and above what like your homeowners or car insurance, but it can be helpful in professional liability mishaps. I have one myself. I'm always advising clients, that might be something they want to look into. It's not foolproof. It's pretty inexpensive. But yeah, I would, someone acting as a sole proprietor or partner, maybe to look into that, see if it fits into their budget, let them know it's an option. Again, it's something I have myself, and I always recommend. I would recommend all of you maybe consider it as well. So turning now to limited partnerships. Now, this is the first entity where you got to start observing laws, formalities. You can see my citations there. So a limited partnership is a situation where there is a general partner and a limited partner. The general partner has unlimited liability, but the upside is they get to control the business. Now, the limited partner is kind of the silent partner, an investor, but they don't get any involvement in the day-to-day operations, but they are limited in liability to their investment. So kind of the typical example you'll see with something like this, maybe a mother-daughter real estate business, okay? So let's say the mother's a doctor. She has the capital. The daughter's just getting out of school, wants to start her business. So, mom gives maybe $100,000 as seed money for, a down payment. Well, with the way the housing market is, maybe that's only a partial down payment at this point. I don't even know. But yeah, so the mother, she puts in her money, and then the daughter runs with it, purchases the property, makes the improvements, finds the tenants, all of that. Now the daughter's running the day-to-day business, and mom doesn't really get a say. But again, if tenants aren't paying, mom's, losses are limited there to that initial investment, whereas the daughter could be personally liable. It's a good structure for this type of situation. The limited partner can get some very passive income. Downside is they don't get much say in the operations. General partner, it's a good way if they don't have capital to really get running with something. So it's not a bad structure for something like that. All right, moving on to limited liability companies. And I'm sure, we've all seen this. It's becoming more and more common. Again, you need to file appropriate paperwork. Again, you see my statutes laid out there. So it's a hybrid structure. It shares characteristics of a corporation and a partnership. It shares limited liability with a corporation, but pass-through income taxation with a partnership. I just want to reference right now, I'm not a tax attorney. There are tax people and there are non-tax people. And the one thing non-tax people know about taxes is to say they're not a tax person and refer you to a tax person, whether that be a CPA or attorney. So I just want to make that clear that I don't talk to your tax attorney with tax questions. Now, the LLC it's very flexible and it's really well suited for entities with a single owner. I do a lot of real estate work, and I see a lot of LLCs. I see situations where, imagine a street, 1, 2, 3 fake street, 1, 2, 3, 4 fake street, 1, 2, 3, 4, 5 fake street on the street. Each of those entities are likely in their own individual LLC. So 1, 2, 3 fake street LLC, 1, 2, 3, 4 fake street LLC, 1, 2, 3, 4, 5 fake street LLC. And then the manager and kind of overseer is another LLC, usually titled like, fake street LLC, that kind of runs them just to put layers of protection for liability. I think I may have seen a chat there. Oh, perhaps not. Okay, so yes, in my career, most of the entities I've dealt with fall into this limited liability structure. It essentially limits owners from personal responsibility for debts and liabilities. Again, and I see it a lot with real estate investors. Now talking about corporations, you see my my sites here, and it's very similar to some of the things I've been talking about thus far. One thing I want to highlight in this section, which we'll talk about more later, is you must follow the formalities for these entities, or you're going to run afoul of the veil protection. Veil protection just means members of the company are shielded from liability connected with the company's actions. So a creditor can't come after you personally. Now, where you can run into trouble is if owners start intermingling funds, then that kind of corporate fiction of a separate person, it can be pierced in litigation and the protection won't exist. You're putting in, you're telling clients, to put in all this work on the front end, but if they're not maintaining it throughout, then they're going to open themselves up to liability on the back end if something goes wrong. So it's important if, whenever you're talking to someone, sure, we set it up, but you still got to be disciplined and treat this as a separate person. Basically, you need to keep business and personal assets separate, separate bank accounts, books, that sort of thing. And again, I'll go into a little bit more on this later. Okay, so now professional corporations. Now this is where licensing is kind of the big issue here. It's a profession where you need a professional license. So think physician, engineers, accountants, and then like yours truly, attorneys. All directors, decision makers, they got to have the appropriate license. I have heard rumblings about how, at least in the attorney field, this might be going away or developing. A lot of insurance companies and banks are interested in getting an ownership stake in legal field, in a law firm, having law firms work for the company in order to reduce costs. I don't know how that is developing, but it's just something that I've heard presentations on and things like that. So something to keep in mind. So now we have the professional LLC, and it's the same idea as the professional corporation, but it's for an LLC. In both these slides, I've listed out the statutory citations. I'll give you a minute to look that over before I switch to the next slide here. All right.
Hey, Nicholas.
Yes.
I have a question.
Sure.
How do you think? What is the significance, or what are the with the new court rules, Supreme Court rules allowing non-attorneys and attorneys to have ownership in basically in a law firm, for firms that are wanting to form professional LLCs? Do you have any views on that, about how that would work, or can those organizations not be formed as professional corporations? because of the mixed ownership.
I am honestly not sure exactly how that will shake out. I haven't looked into that issue. I imagine things are constantly developing. So I imagine there's going to be, if the professional corporation doesn't work, there will be another like hybrid structure. That's kind of how the LLC came about. You wanted those protections from the partnership, but also the benefits of a corporation. So maybe there's just a new frontier coming, and it'll be a new, a whole new type of entity. But honestly, I'm not sure. I don't have my crystal ball this morning.
Oh, okay.
Okay, so moving on to the nonprofit corporation. So these are entities that are essentially, they're not purely for profit, but instead serve the public good. An important thing to remember here, again, is on top of state regulation, you need to make sure you're following the IRS rules. It's just about that time to file our taxes. I think, it's never a bad reminder to not run afoul of the IRS. Slide. Okay, so here are my 4 big takeaways. And yes, this is an excuse to show off pictures of my kids. Okay, so sole proprietor and partnerships, they're the default entities. The major reason for a business entity to form is to protect personal assets. Let's see here. Other entities, besides the sole proprietorship and partnership, require following formalities. And again, something to harp on, but we probably all know, again, as legal professionals, it's always best to go back and review the rule, review the statute, review the case law. Okay, so now I'm moving on to operating agreements, bylaws, and shareholder agreements. Okay, so these are the documents that are going to govern corporate structure. This is basically where you set up the rules of the entity. There are important documents to observe, or you risk losing that structure and open up the possibility of the piercing the corporate veil or argument that I was talking about a little bit before. So we're going to get into some basics here about these documents. An operating agreement is going to be used for an LLC. It's legally binding. It outlines things like management, ownership, structure. It can be seen as governing the internal operations of the business. You cater these to specific needs of your business. The lawn mowing company I was talking about is going to have different particular needs than the mother-daughter real estate company I was talking about. Usually, operating agreements have a basic structure. You can find a template and build off of that, but it's just important to remember to cater the document to your client's particular needs. There is a good statute in Arizona that, if an operating agreement doesn't exist, Arizona law can control, and it's a more or less a fail-safe. I'm also licensed in Illinois and Wisconsin, and I'm just very impressed with the Arizona statute on this. We're litigating a case right now where there's a very good possibility the operating agreement doesn't work, so we're able to go back and look at that, rely on that for filling in gaps. Okay. Now, just want to talk briefly about bylaws and shareholder agreements. So bylaws they're used for corporations. It's basically the same function as the operating agreement is for the LLC. Sets the legal backbone for the business and governs its operations. Now, a shareholder agreement it's optional. It creates certain rights and obligations among shareholders. You're more likely to use a shareholder in a closely held entity to ensure, someone's not bringing in an outsider. For instance, you have a family business, 4 siblings running the business. You don't want, youngest brother to sell shares to old high school friend and bringing them in to kind of have a say in how the business works. So that's where you see them. But again, they are optional. Some more 4 big takeaways here. Okay, we have operating agreements are for LLCs. Bylaws are for corporations. These are the documents that govern internal operations of a business. Shareholder agreements are optional and again used mostly in closely held entities.
Hey, Nick,
Yeah.
what are your thoughts about how specific operating agreements should be? I mean, you know, we've all of us that do that type of work have seen and probably have the boilerplate operating agreements that basically grant management authority to any member, or if it's a manager-member structured agreement to the manager. You know, what are your thoughts about how specific those operating agreements should be, and if they're not specific and there are problems between the owners or managers, how does do the default statutes address those issues?
Well, again, the default statute, it's a fail-safe, so it's not perfect. You definitely want to tailor your operating agreement to the specific issues between everyone. And it's always hard when you're forming the entity because everyone's on the same page to start. Everyone's making money together thinking this is going to be great. A lot of times I know I get pressured from clients that you have to push off, like, let's just wrap this up, let's hurry up. But I do suggest more detail, but also leaving in fail safes or options. I'm going to talk a little bit about business succession planning later. And there can just be situations where, you know, if not all members can execute documents, then what if that particular member is disabled or passes early? What if there's a fight? So I favor more detail, but again, you don't want to get so specific that you draft yourself into a corner if litigation comes up or something does go wrong.
So you would typically put in detail about daily responsibilities, for example, or if someone has responsibilities over certain areas of the business. I mean, I find that those are the biggest, when people come to me with problems, those are the biggest factors, along with how money is spent. If there's any limitations on, buying things like equipment or just making expenditures over a particular amount, or who's on the bank account, who does the accounting.
Yeah, it's just I feel that the more vague the document is, it's a fine, there's a fine line, because again, if it's too specific, if you draft an agreement too specific, then perhaps no one can live up to those standards, right? But if it's too vague, then there's confusion about what responsibilities are. I always encourage, people that I do work for to stay in communication. Maybe you revisit your operating agreement, more often than not, just to discuss and work through problems. Again, a lot of times you start out this company thinking it's going to go one way, but then, there's a new opportunity, just like in the real estate, sector, you think you're going to be long-term buy and hold residential real estate, but wow, prices have gone up so much, you can't necessarily make the money you need to service your mortgages. So you got to get into vacation rentals or something. If your business documents are too strict, then are you going to be able to make that pivot? So I definitely, I've litigated cases on both sides where it's just a very strict document, and then one that's way too vague and open for interpretation. I don't know if there's any one right way to do it, but I do prefer myself more detail.
Yeah, I've had I've seen a lot of problems with, especially with family members, but also just with non-family members, and often these people are friends that purchase investment properties, and maybe they have an operating agreement, maybe they don't, but the problem comes up when somebody wants to sell, or somebody wants to make an improvement, and they can't agree on that. And so
Yeah.
what do they do? And I think I have no way of knowing this is true, but in my experience, most of these small investors don't have operating agreements, don't have any way of resolving that conflict. And so it can be a real big deal that lands them in court.
And then it's just so much more expensive, heartache, hassle. It's just so important to have your documents done right up front. But people skip that step. Yeah. The statute in Arizona, it is good. It is good. But yeah, a detailed operating agreement, that's better. It really is.
Well, and I apologize. Last question for right now. I don't want to monopolize your time, but I had one other question from the beginning, kind of the beginning of your presentation. I'm just curious. Most of the LLCs that I would form, I'll use the online system with Secretary of State's office, and just use their, which generates the the documents that they have, the articles of organization. Any particular downside to using that, or are there just gross deficiencies that you think should be uploaded in an addendum to that, or what are your thoughts about using the online forms for the for the initial documents?
I think that's fine. It depends on the complexity of each individual entity, obviously. I think, frankly, those documents are probably workable. It's nice because they're consistent. You're going to see it all the way through. Sometimes, if you veer too far outside of kind of these forms, that can lead to problems itself. So I don't see any problem with using the forms provided by the state. No.
Okay, thank you.
Yep. All right. So the next topic I would like to talk about here is business succession planning. This is basically a series of decisions about, how a business will go in the event of retirement, death, or disability. This is something that business owners don't really think about on the front end. On the individual level, it's equivalent of, a life insurance policy or a disability policy. People don't like to think about it, but it's really important to have it in place and to be thinking about these things. If there's not a good plan, things can get messy. I've seen litigation where it gets very ugly, especially in the closely held entity context. A business succession plan can, protect employees if something happens to owners. They still need to pay their bills if something happens to the owner of the business. And I'm going to talk about just highlight, you'd want to talk to an insurance professional about products available. I'm going to discuss them a little bit here, but definitely you would want to work with someone to make sure that the business is in the right product. Okay. So the first agreement here is the buy-sell agreement. It's an exit strategy for business partners. It spells out who owns what when a partner leaves or there is a business breakup, a business divorce. There will often be a sales price for a member's interest. Details, how and when shares are distributed to the person designated to take over. this is just one of the options we're going to touch on. Pretty simple. So the next one here is the cross purchase agreement, and I apologize for that long paragraph. Probably a little bit tough to read here early on a Saturday morning. So basically, this allows partners or shareholders to purchase the interest of the partner who becomes incapacitated or who dies or more happily retires. Basically, you're taking out a life insurance policy on other owners. If there are multiple owners, you would have like a trustee, perhaps, and then this way the owners don't have to take out multiple policies against each other. The trustee basically just takes out the policy on each owner, and then when someone dies, the trustee facilitates the funds to the remaining owners. Entity purchase agreement. So this is a situation where the business itself purchases the interests of the departing interest holder. It's similar to the cross purchase agreement, but there's no trustee there. It's used in situations where there's more than one owner. Usually the business takes out a policy on each owner and amount of their stake in the entity. A sum is collected upon death and is used to buy out the shares of the business. Next, the wait and see agreement, which I don't know, as a legal professional, I don't like the title of this. It just sounds risky or something. But this is a hybrid agreement. It combines the cross purchase and entity purchase agreements in kind of the typical situation here. So that entity has the first option to buy stock from a deceased owner's estate. If the entity either doesn't exercise it or only maybe a portion of it, then the remaining owners have the second option or the remainder. And then if any interest in the company remains unpurchased, then the corporation must purchase the remaining portion. It assures the decedent's family and that all the stock's going to be purchased, and assures remaining owners they'll succeed to control. You obviously, these entities, they're in business together. It's kind of like a work family. You become friends. You want to make sure you're taking care of each other's family, but also you don't want necessarily some outsider who you don't want to work with coming in. So these are just some ways to protect yourself, protect your family, and then protect your partners who you're working with. All right. My next 4 big takeaways section here. So having a succession plan, it's just critical to ensuring the business continues. They protect employees while company winds down. Several different ways to do it, and you just got to find the right fit. And talk to an insurance professional about the right product for the situation. Again, it's a really important thing, not a pleasant thing, but a very important thing to talk about on the front end. Reminding people like, hey, if something does happen, what's happening to your employees? What are your partners going to do? I have a lot of situations where I raise it and then they're like, we'll worry about that later. And then, later never really comes. So just something to keep in mind. I recommend to people, again, not a pleasant topic, but it is important. Okay, the next section here we have is employment and independent contractor agreements. So I talked about this a little bit before, talking about that lawnmower example. The general rule is you're an independent contractor if the person paying you only has the right to control or direct your work, not the way it's done or how it's done. An independent contractor, it's not an employed payroll employee of the company. Now, an employee generally is directed by the employer and on the payroll. An employee is more subject to the whims of their boss, whereas the independent contractor gets to kind of more or less call their own shots. So an employment agreement, here's some bullet points. Essentially, it's an agreement that spells out rules, rights, and responsibilities of the employer and the employee. It would include like special obligations unique to the hiring situation. Office work is going to be a lot different than that landscaping, which is going to be a lot different than that real estate investment company. So you're gonna, again, there are good templates, but there might be, super specific requirements or things to consider for the particular entity, and you just got to keep that in mind. Definitely probe the client and try and drag it out of them. If there's anything special they want to include, and we'll talk about an example here in a second. So different employment contracts include permanent, temporary, independent contractors. I think we're probably all familiar with these sorts of. We've all probably been in either in an employment agreement or an independent contractor relationship, if not both. So the independent contractor agreement, as you can see, there's overlap with the employment agreement. It basically outlines the terms and conditions of the work arrangement between the contractor and the client. I find this area just kind of fascinating. I've been practicing for 10 years, but the proliferation of the gig economy has just been, I think it's been moving just breakneck speed. I think these type of arrangements are going to be more and more of the future. I see a lot of these in the real estate context where, the owner has an independent contractor who's the property manager who independently contracts with contractors. Where the part I'm just fascinated with it is with more of the white collar professions. I have attorney friends who are just complete gig attorneys. There are platforms you can use that have, agreements embedded, but they also do their own thing where they're just taking the type of work they want to do, motions or, review discovery or whatever, and they have their separate agreements with the attorneys they work for. So, this might be a good niche to get into, to really learn and understand it, because I just think we're going to see more and more of this. Okay, a second one here, because I love independent contractor agreements so much. Here's some more considerations. So, and this applies to the kind of employment agreement a little bit too, non-compete sort of clauses. So just think of like a house cleaning business who hires independent people to be the workers at the homes, right? Something you want to lay out in the independent contractor agreement is, that intellectual property of these business owners. The contractor who's going to the house is the family cleaning. Maybe the family actually thinks the independent contractor is the person they're working for. So what's to stop this person from spinning off and starting their own business, taking all your customers? So that's something, those sorts of issues unique to the specific business is something that's got to be thought of. And I know I sound like a broken record, but it's got to be addressed on the front end, or else you're running into problems later. All right, my 4 big takeaways here. Employment agreements govern the employment relationship. They're permanent, temporary, independent contractor agreements. The independent contractor versus employee kind of comes down to how much the person who hires you is calling your shots, directing your work. And then just something I like here is the gig economy's brought a ton of change. I don't see that stopping in any time in the near future. So it's just a real interesting area to keep your eye on. So how am I doing on time here? Oh, we're all right. Okay.
You're doing great.
Okay, perfect. Business purchase and sale agreements. These generally include, terms of sale, what is or is not included in the sales price, optional clauses and warranties that protect both sides of the agreement. You need to be careful when drafting these. Like we've talked about, they're like special quirks for each business. It's important to make sure you have all the details of the business. Again, physical property versus intellectual property, how outstanding payments are allocated. An attorney sells her practice and she's got, all these accounts receivable, or a personal injury firm, maybe, they worked up these cases, like how are you splitting that? So these are just some considerations with the purchase and things to keep in mind with purchase and sale agreements. Okay, so here are some elements of what goes into the purchase agreement. We're legal professionals. We know the big thing here: I's dotted, T's crossed. Make sure you have everything. Make sure you know all of the assets. That real estate company, if you're transferring mortgages, are people refinancing? Are there tenants? Get those leases. The lawnmower business, if that's being sold, is there a truck involved with the company? All the lawnmowers, the client list, So it's just different for every business, and it's important to remember that. So here we go. Piercing the corporate veil. This is something I introduced a little bit earlier. This is basically a situation where the creditor gets to pass the corporate formalities and get at the owner's personal assets. Again, you put in all the work at the beginning to form your entity, but you ignore these important requirements, and it's as if you didn't even do anything to form the entity. Okay, and I apologize for this long paragraph. Alter ego liability. This is just allowing the obligations of the corporation to be treated as those of the shareholder. Now, I have a 1985 case here, but this case was cited in a 2015 unpublished case, and I'm just going to read you the quote, because there's nothing better than being read quotes from cases early on a Saturday morning. A corporation is an independent entity, and as a consequence, the assets of individual stockholders are generally protected from the debts of the corporation, and the assets of the corporation are protected from the debts of individual shareholders. The corporate veil may be pierced when the corporation is the alter ego or business conduit of a person, and when observing the corporate form would be unjust. And then, if you want the case site, it's Sonoma County Chevrolet Inc. versus Hardesty, 2015 Arizona app, unpublished, Lexus 236, and that's an Arizona Court of Appeals unpublished decision.
So what does that mean?
Oh, I think I might have gone too far here. Yeah, basically, that's what I'm laying out in the next little bit here. Okay, all right, so here are some factors in determining alter ego. Basically, the company doesn't have enough money. You got to perform the state mandated requirements. And this is, okay, so the big one is keep personal and business assets separate. I see this a lot. Lay people don't always understand that the company is a completely separate person, really. And they access the corporation's bank account like it's their own. When I'm talking to people about this, they're like, but it's my company. And it's like, yes, and I understand that, but you don't want to run the risk of, what if something happens with your company? You don't want your personal assets exposed. Customers need to know, you're operating as an entity and not, you're not just doing business as the person. And then keep excellent records. My dad had he had his accounting degree, and he was always harping on keep meticulous, pristine books. That makes me think of my dad there. All right. So here's some, more corporation formalities. These are steps and precautions a business must take to ensure the corporation remains legally distinct. And just here's a list of some of the examples. LLC formalities, generally fewer. Here's a list of things that must be done. I'll give you a second to look at that slide. Okay, and then the 4 big takeaways. Piercing the corporate veil exposes individuals' assets to business liability. Observe the corporate formalities. I know I've said that a bunch of times and sound like a broken record. You got to keep the business completely separate. That's what it comes down to. It's not a personal piggy bank. It's very important to remind people, again, on the front end. And we can lay it out as much as we can. As the legal professional, people are going to do what they're going to do. But it's important to highlight it's a completely separate person. It's a hard concept to understand, but you just got to hammer it in and then, keep meticulous records. And my children are looking inquisitive in this picture, so I'm just wondering if there are any questions.
I think I had a couple questions. I had a question about the business purchase and sale agreement.
Sure.
Oh, actually, before that, we were talking about you were talking about business succession planning.
Yeah.
And I don't know a lot about this, but I have seen in some operating agreements a reference to basically a beneficiary deed.
Okay. Yeah.
I'm wondering if you could talk about what that is and how that works.
Yeah. So, kind of in the event of death, who is taking the property? It's a good way to preserve. I'm assuming you're seeing this in an investor context, maybe a long-term buy and hold sort of situation.
Well, I'm talking about like doing a beneficiary deed for someone's membership interest. So even in a closely held company, let's say for whatever reason, I'll tell you where it came up, what context it came up for me is that I had some Canadian clients, which there's lots of Canadian investors in the state of Arizona, as many people may know. And I've had and anyways, I guess there are issues with doing living trusts in Canada that they don't recognize them or something. I don't know all the ins and outs of that, but they did not have a trust, and so they wanted to have a something else, and the tool they used was essentially a beneficiary deed for the business interest to leave that membership interest to their children.
No, yeah, that's a great tool. I see beneficiary deeds more in the real estate context. It depends, and again, great way to do the membership interest, but it wouldn't, I don't think, take care of all necessarily parts of the business. I'm not sure what type of business this is, but just sending the membership interest to the children. Like, for instance, what if there's a mortgage on the property? Do their need, or like, what happens with like personal guarantees or something like that? I think that's a great part of a business succession plan, but I think, and again, it depends on if it's a very simple business, then yeah, maybe it works. But I think that is a really good part of the overall kind of succession plan. And
Okay.
It wouldn't necessarily help though with disability either. Disabilities, I don't think I gave this example, but I had someone get knocked out by COVID. His wife wasn't on any of the books. She couldn't write checks. She couldn't pay employees. It was a tough situation. So again, I think that's a good piece of the puzzle, but depending on the business, it might require more.
Okay. And then the other thing that's kind of related that I've been curious about is when I understand that like with a bit, even if you have built into the operating agreement or a separate purchase agreement of subtype, that when if someone dies and let's say the heirs acquire the interest, um, or they sell their interest, most operating agreements, if not all of them, don't allow that the new member, they allow the member to reap the profits and share in the profits that they've acquired based upon the membership interest, but they don't transfer management authority. And I'm just curious if you could talk about that, why that is, or if and there are ways around that.
So basically, it's a situation where there are like several owners who manage and get profits, and then they deed their or transfer their profits basically, but no management. Is that the situation?
Well, I'm just saying, let's say one of the members dies. That could be one scenario, and so their heirs acquire their membership interest, or just you have a member that sells their interest, with the permission of the other members. But let's just focus on the inherited membership interest. It's my understanding that the inherited membership interest does not come with the management authority that person had as a member.
Yeah, I could see that situation. The parents, let's just call it the parents and the kids, for instance. The parents form this business entity, they run it, they want to pass on wealth to their children, but the parents aren't necessarily going to want to be in business with their friends' children. And, it's simply because, the parents were excellent in their field and could run the company. That doesn't, follow that the children are going to be equipped, frankly, to run the business. So maybe this is, I'm not sure if you're talking about a particular situation, but just maybe that's a situation where, hey, I want my kids to be taken care of, but, they don't, know how to run a used car business or whatever it is.
Well, what I'm really asking is that a standard provision in an operating agreement that the membership interest inherited it does not include the management authority?
Not that I've seen. I wouldn't call it standard that I've seen. No.
Okay. All right. Okay. Yeah. Anybody else have any questions? Any questions, comments? I think that was yeah, those are all the questions that I had. All right. Anyone? All right. Nick, if you want to wrap up, I go ahead. Anything else that you wanted to talk about?
No, I just want to say thanks again for having me. I like talking about the law, so it was a really good opportunity to meet you guys. If you ever need anything, or have a question comes up later, feel free to reach out. Again, I'm with Fowler St. Clair. Always happy to talk about the law.
All right, and we always appreciate the attorneys from your firm coming and being willing to teach at these webinars or seminars in person, and we certainly hope to have you back. But yeah, if that's it, well, let's I'll give a thank you and a applause for your presentation. Thank you, Nick, and I think what's the best way to contact you if anybody has a question or a referral or?
Sure. My email, I can just provide that. It's my last name, Strom, at fowlerstclair.com. You can just Google our firm. We have a pretty nice website. But email's the best way to probably get hold of me. Again, that's strom@fowlerstclair.com.
Okay, and I have your PowerPoint, and I assume your information is on the PowerPoint as well. So I'll be sending that out along with the certificates of completion.
Perfect. Well, thank you so much
All
for
right.
having me. I hope it wasn't too dry for a Saturday morning. I hope people enjoyed it.
Not at all. Enjoy your Saturday with your 4 children.
Thanks. I got to go chase them around. Mom needs a break.
All right. All right. Thank you very much.
Yep. Take care, guys.
All right. All right. Well, so that will conclude the first presentation. So the next, go ahead and if anybody needs to take a quick trip to get a drink of water or go to the bathroom, go ahead and do that while we get the next one set up, which should only take just a couple minutes. But let me get Kelly set up. Bear with me for just a minute. Okay. All right. Now, before we get into the next presentation, I am going to, or actually, I just told everybody they could run to the restroom or whatever, so I'll wait for a minute. But before Kelly gets started, I'm going to go ahead and give everybody the first verification word. But I'll wait for a second on that. You know, I also want to comment on what I appreciate Nick's presentation. One of the things that if anybody out there is not really doing LLCs, corporations, or the like, some of the things that he just went over, it's certainly an area that many LDPs are involved with. I would encourage you to check out the Arizona Corporation Commission's page on how to upload, how to do different things, or how to utilize their system, which is very simple. I can't think of a system that is any simpler to use. But they also offer the forms that you can download off their website if you're still wanting to do things, I'll say the old-fashioned way. But it's a great area to be in. It's a much needed service in the community for people to form various entities, and easy to get involved with. So, all right. So I am going to start to hold up the first verification word. And I think a few people have walked away, but I'll give them a couple minutes. I'll hold it up a couple times. But the first word is foot. F-O-O-T, foot. So this is the first verification word. You want to write this word down and make sure that at the end of the webinar, you'll have 3 words total to email me, and I will respond to your email with your certificate of completion. I'll also send to you your whatever handouts that I have from the presenters today. So that's it. Let's see, a couple people dropped off. Okay. Okay, again, the word is foot. Okay, everybody have it? I hope so. All right. So, let's see.
Dawn, could you say that again, please?
I'd be happy to. So the
Okay.
first verification word is foot.
Okay. Thank you.
No problem. Okay. All right. So our next speaker today is Kelly DiCarlo. Kelly, welcome. Kelly, I'll let you talk about yourself in a sec, but I just want to say Kelly's going to be talking about e-filing in Arizona courts, which is an exciting and developing topic for not just for attorneys, but for certified legal document preparers. And again, Kelly, I'm sure we'll get into a lot of those different things. So Kelly, you are spotlighted. So you should be able to share your screen if you want to, but go ahead and take it away.
About how many people do we have present today, Don?
I believe we have about 42.
Okay. And I know we're not in person here, but I'm curious how many people are already e-filing right now.
How about whoever's e-filing, would you mind just kind of raising your hand for a moment?
And I don't know if you want to say something in the comments or just say something, out loud. How many are filing in family court as opposed to civil court or any other area? I would assume those are the two areas doc preps would be filing in.
So lower your hand if you're not, raise your hand if you are. So what was it, Kelly, about?
I see some hands raised, but I can't really tell.
I can tell you there were about 10 people that raised their hand that they were e-filing, and I think there's 2 or 3 that said they were doing so in family, which was your second question.
Yeah, I see both too. Today, I'm going to just give a brief overview of the e-filing. There's 2 types in Arizona, and then I'm going to narrow down a little bit on family. That's where I do e-filings, and there's been some changes in the family e-filing. And Don and I just found out recently that our board, the document preparation board, is going to be addressing e-filing and doc preps and LPs at the meeting on Monday. So we'll see what they have to say too, and I'll show you some of the things that relate to that. So there's 2 types. I'm going to share my screen here so you can see some things on my computer. And Don, tell me if anything comes up that, well, I can tell what's coming up right now. So at the Arizona Supreme Court, they have training available for filing, and there's 2 types of filing in Arizona. There's the turbo court and e-filing. There used to be in Maricopa County, you could e-file in family court right through the Maricopa County website, and that stopped on June 1st, 2021, and went under the e-file Arizona. Both e-file Arizona and Arizona Turbo Court has training that you can do. I think the Turbo Court is more advanced. It's been around a lot longer, but the e-filing in family court is the only way you can file documents now electronically that I'm aware of. I'm sure there's some, exceptions that most likely don't apply to doc preps, but and there is a possible, there may be a possible clarification on Monday of how doc preps and our rules relate to e-filing. And I'll get to that here in just a little bit. I also know that in civil court, you can file in turbo court or e-file, but for family specifically, it's only under e-filing. So if you click on this link here, it'll take you to this page, and you can see at the top that they have live online training sessions right now. And this is for civil, criminal, juvenile, and family for attorneys. And then they have family law e-filing training for self-represented litigants, which I would assume that would be the one that'll be relevant to anyone filing on behalf of self-represented litigants if there's no issues with it. I don't know what's going to happen with the board. Maybe nothing. I'm not sure. It's just something we just found out that's going to be discussed on Monday. But anyways, if you click on the link, currently all they have is live webinars that you have to register for through Eventbrite. But they are in here. You can take those and they'll, I'm sure, go into much more depth than what I'm going to do today. I'm just going to kind of give an overview and provide some other information relating to doc preps. And in addition to that, there is all these links you can click on for help that, help with the registration, preparing a submission, payment methods, e-service, and as you can see on the screen. I do have some handouts that I'll provide to Don that he can provide to you when he sends the certificates. But this is the place, this is where you want to go if you're just learning about how to file and what needs to be done. There's also some additional resources that I was able to locate. There are two main ones that I'm aware of, and I've spoken to. One is just the clerk of court, and that's in whatever county that it is. I've spoke to e-filing clerks in Maricopa County, and I spoke to one in Yavapai County. All were extremely helpful. When you do an e-filing, it is going to be that court, that particular court that accepts it. So if you're filing in Pinal County, you're filing in Yavapai, you're filing in Maricopa, that's where they're going to review and accept or reject what you're filing. And I also was made aware of AOC support through the Arizona Supreme Court, and I spoke with one of them as well. There's a phone number for Phoenix, and there's another phone number. I'll provide that for Don to provide to you as well. But when I called into the AOC support, the person I spoke with said they are primarily for technical issues. If you have a rejected filing, they do have notes on the filing. It can give you basic information, but you'll probably get better information by calling the clerk of the county that you're in. You call in and you go through, like Maricopa County, you have to punch all the different numbers to get to e-filing. But they're the ones that I was told could better help if there is a rejection. To an extent, they can help you, determine what needs to be done, what was wrong, that sort of thing. To be honest, I've done e-filing, but I haven't really had a rejection for anything that was a technical issue or, rejected for another reason. So this is one of the best resources you can go to figure out how to do certain things. And then you can reach out to AOC support for technical, and then the clerks at the different counties. The ones I've called and talked to have been extremely helpful. So one of the things I wanted to do is show you an example of filing. And then I want to go into the administrative order that was put out by the Supreme Court. I'm going to bring that up on the screen here in a little bit. But first, I just wanted to show you a quick example of e-filing. And then I want to present this admin order and go over it, because there's a section in here on self-representative that I'm curious to see maybe what others think of it. And I'm also wondering if it's going to be addressed by the board at all on Monday, and how we go about filing properly for people that we assist that are self-represented. So real quick, I just want to jump into the screen to show you an example of filing. This is in family court. It's e-filing. I'm already past the logging in screen. Just trying to be not put it all out there, but I have a case that I'm going to file in, so it's not disclosing anyone's private information. It's actually a case I had many, many years ago, but I'm going to use that as an example with just some kind of dummy forms to take you all the way up to the point, hopefully, where you would be paying. And I do have some information about the payment that I think is important, because I think there's been some misunderstandings about that too that can save money. So in this particular case, I'm going to file a motion. And now throughout the state, according to this administrative order that I'm going to show you, you can file initial filings. I have not had the opportunity to do that yet. One of the clerks I spoke with said that it's primarily DES doing it right now. And then the person I spoke with at AOC said anyone can do it. I just haven't had the opportunity, and I will be doing that in the near future. But in this particular case, I'm not starting a new case. I am going to be filing in an existing case. And in this case, I just did a quick motion to extend. So I click, that's your two choices here, that you want to start a new case. And the other one is I have a case in the court I selected and would like to file in this case. And that is going to be this example. So in this screen, there's just information for the account itself. In the next screen, I'm going to put in the case number. 09. And when you put in this case number and click the link, the search button, it's going to populate it for you. And this is where whenever I do any electronic filings, I make sure I'm in the right case. There's other information here that is, in my experience filing, it doesn't apply to what I'm doing. So usually I just check this screen, make sure I have the right case, and then I go to the next page. Here is where you add your lead document. And in this case, this is how I do it. If anybody does things differently and wants to provide that information, I welcome it. But in this one, I'm going to be filing a motion to extend. And then we have to go into the document category, which in this case is a motion, document type. In a lot of cases, I just put motion because you're going to put the title of the document right here. So let's say that's motion to extend. And then here you're going to put how many pages it is. Personally, I can't remember exactly how many, so let me pull that up. There's a motion example. Let me look at it one more time just to get the number. 2 pages. Okay. So in this case, this is going to be 2 pages. And it does verify you have the correct number of pages. And if you don't, it'll tell you there's an error and you have to go back. I'm uploading the motion in a PDF format that's required to upload it. And here I'm going to save. And once I save it, I can go here and check and make sure everything is good. I double check everything. The last thing I want to do is make a mistake filing. So this shows me this is the document I'm uploading, and in other cases I make sure they're signed and everything's correct. But going back to this screen, in this particular case, and one of the things I really like about this filing system is you can upload the proposed order and you can do it, and it actually requires you, or at least the filings I've done, to do it in a Word format where the judge can actually, or his or her staff can actually go in and amend it. And I actually had one that was granted recently, and they actually went in and typed different, what they wanted in that document. So here I'm just going to put proposed order. In this, I know this example is just a motion, but there's some documents you're going to file that could have exhibits. This is where exhibits would be uploaded as well. I'm going to assume this order is 1 page. Let me see. If it isn't, you can see what the error sign's like. Yeah, it's 1 page. Okay, so then you upload your proposed order, and you can do it. I don't know why this screen's coming up again. Oh, I need to hit save, sorry. And then I can see here, check it, make sure it looks okay. Sorry, it's running slow. Maybe I need to click here. So I can see here that the order is uploaded, and double check it and make sure it's all good. Now, going back to this screen, now that I know that everything's good, you can see there's already an application fee, the fee for using this application to do the filing, $6.50. I'm going to hit the next button, and here is where I can choose who to serve it to. I'm not going to serve it on anyone, but on that particular screen, what's important to know is if you click service, which that is a service that's provided through e-filing, you can actually serve like an attorney on record. You can click it, and it's a charge of $3.80, but it will go directly to that attorney's email, and that's one way of serving the document. But in this screen, only we're paying for the application, which is the $6.50. So we do the electronic payment at payment site, and you wait for this button to come up to say continue to payment site. And then this screen that's coming up, I'm going to click out of it, but it's your last screen that you go into, and it's just basically paying for it. Once paid for, there's the screen itself. And I'm not going to put any information here because I'm going to stop the filing there so it doesn't go through. But once that is paid, then you will get a receipt through emails. Will be 2 receipts. Actually, there's 2 receipts that come through if you're not paying the $3.80 charge to serve an attorney or someone else on record, whatever that may be. But I get 2 emails now. One is the receipt for the payment, and then I also get a submission email. And I always wait for that submission email to make sure it's been submitted. That's the way I ensure that it's been submitted. And also, when serving the motion by mail, email, however you're sending it to the other party or the judge or whoever you're sending it to, I print that submission email that doesn't disclose a lot of information. Like the receipt has financial information on it. But anyways, that I use as the filing receipt to send with anything that's filed electronically. And that's basically it. Just a simple, quick showing you how to file something. Does anyone have any questions on that? And I got the screen back. Or comments or anything you want to add to it that would be helpful for other people. Okay, I don't see anything. Do you see anything, Don?
Not yet.
Okay, let me get back to my screen. Okay, so that was just a quick example on e-filing. And what I'd like to go into now is, I think this is relevant to anyone that's doing e-filing. Yes, there is an administrative order from the Supreme Court regarding the policies for e-filing of family law cases, and this will be one of the handouts that I provide to Don. In this, it has, all the specific information and also deadlines. Attorneys are now, e-filing has been going on in Maricopa County and required to be filed in Maricopa County since June 1st, 2021. And this was, I know, disappointing to some people because we went from free filing to all of a sudden we had to pay for it. Pima County and the other counties were just came in recently, but all counties are going to be required, and this is just for attorneys. Attorneys are going to be required to file case initiating documents beginning June 1st, they're going to be required to file June 1st, 2022, although you can do it now in Maricopa County. You can file initiating documents. Again, I haven't done that yet. But this order from the Supreme Court lays out all the information regarding e-filing. And I think it's important because it has, definitions, it explains how things work, but it also is telling you how things should be done. And there is, self-represented litigants are the people that we assist. And I don't think this is a new thing. And I don't know that we've got clarification on everything, which may be coming on Monday from the board. But I'm not going to read all this to you. There are exclusions of it's going to continue for us that we can file over the counter. For me personally, e-filing can be it can be more convenient in certain situations. But in this particular rule, administrative order, which I believe you should read if you're going to be doing e-filing, because it tells you, what you can file, what you cannot file. But then you go down to a section, they have the fees that are broken down. You have the $650 to initiate a case, $650 to e-file an attached document, and that $380 if the filer elects to use optional electronic service. All fees must be paid at the time. That's typically, yes, the way it's done, although I still occasionally, we get calls sometimes. But the thing that I found interesting in here was the signature standards. And this is any document displaying the symbol /S/ with the printed name of the filer is deemed signed by the named person for purpose of rules and statutes governing practice and procedure in the courts of the state. We use DocuSign. I know a lot of other people do, and attorneys do as well. And there has not been any issues with DocuSign. But they discuss the responsibilities for an attorney, judicial officer or clerk, and then they have a section on self-represented litigant. Documents e-filed by self-represented litigant must be filed under the self-represented litigant's registered login ID and password and are deemed signed by that self-represented litigant for purposes of rules and statutes governing practice and procedures in the courts of the state. So this, what I would like clarification on is, it appears to me that it requires the self-represented litigant to have their own account and not one account where different people are being filed under. So we'll see what happens on Monday and if there's any light that's shed on that on Monday. I know this is talking about signatures itself, but it doesn't include that I saw talking about process servers using the e-filing, or of course it's their own signatures, and also the parenting class. The providers are the ones that file those certificates. So this one, the thing that I felt was most relevant, of course, to what the services most of us provide, and hopefully we'll have some clarification on that. Date and time of e-filing.
Kelly, can I interrupt you?
Absolutely.
Can I interrupt for a second? Just if you'll scroll back up a little bit.
Mm-hmm.
What do you right there?
Okay.
What do you suppose the signing for another party? Who is that intended to? What is that intended for?
I think that's regarding stipulations. I've seen in the past where attorneys get permission and they can sign something on behalf of another attorney, or I believe a party I've seen before too. That was what I picked up from that one.
You would think it would be more specific if it was only intended for attorneys.
Well, it says such as a stipulation. So an example, a person filing a document containing more than one place for a signature may sign on behalf of another party only if the person has actual authority to do so. That's where I've seen it as stipulations. And that was with, working with attorneys primarily.
Okay.
What do you think, Don?
I don't know. It's a little vague, which I like.
Mm-hmm.
But that'll be something I will bring up Monday at the meeting. Also, I just wanted to tell you, Kelly, there was a question or comment in the chat from Lupita. She says, so a PDF document that requires to be submitted, does it mean that we can create the document to upload, or the system will create the document?
Let me look at this closer.
Excuse me, I'm losing my voice already.
I'm not sure what that question means. So a PDF document.
I think she's just asking if you can upload your own documents when you're e-filing.
As far as I know, yeah. I mean, that's what else would you upload? There are some, my understanding, which like I said, I haven't had experience yet, is on the initial filing, one of the clerks told me they're going to produce the summons for you. And I still don't have complete clarity on the sensitive data sheet. They were saying and I don't know if this is veering off on what your question is, but outside, like your own documents that you're PDFing and filing, which have to be, most of them have to be PDF to file. I still don't have complete clarity and have done it myself and have the experience where what's going to happen with sensitive data sheets and documents that are restricted, because my understanding is when you do the initial filing, you get to upload all the documents in one filing, is what I was told, and they will make the sensitive data sheet confidential. But if you do it on a response right now, it'll come up not confidential. If you file it with the response, you have to do 2 separate filings right now. I'm sorry, Lupita, does that answer your question?
Lupita, you can unmute yourself if you want to, or just when you have a chance, comment in the chat section if that answered your question. Okay.
Okay. Anyways, the remaining, this is, if you're doing e-filing, this is definitely something you want to read. Sorry. This is definitely something you want to read. The family law cover sheet, I think, is going to apply to other counties outside Maricopa County. But it has all the information. There's this one I found interesting because I've experienced something like this before, extension of time due to interruption in service. And that wasn't under this particular, it wasn't under this application, but in the past, doing filings and all different kinds of applications, having a system down and you can't file, and what happens if you're on the the tail end of a deadline? It's a drop dead deadline, and this provides the information of what you need to know in the event something like that happens. I think the best practice is not to wait till deadline, but that's not always the case. anyways, there's additional information here. I think you should read it in detail. Now, the board meeting that's going to be on, let me pull it here. The board meeting on Monday, March 28th at 10 a.m. I'll just bring us back up to here. That Dawn just noticed that on the second page, it says administrative issues. And one of those, 5C, is going to be discussion on e-filing for LDPs and LPs and discussion on R210040 and R22009. And in looking those up, that is a proposed rule change that Judge McMurdy from the Court of Appeals made. And I believe that is on, and I'm not sure how exactly this works because it's regarding electronic signatures. And we have not had any problems finding electronic signatures over the counter or e-filing. But we are using the DocuSign program to do that. And so I'm not sure why this, the need of this rule, if I remember correctly, it was the head of DES that was asking for it because it was such a convenient thing for them. So it may be something that relates more specifically to them. I do see that Judge McMurdy asked for it on an expedited consideration, which was denied by the Chief Justice. So this is, looks like it's currently open for public comment. If you want more information on there, you can go there and look at that. But that's one of the things that's going to be discussed. And the R210040 is the proposed rule change for Rule 26A1 of the Arizona Rules of Family Law Procedure. R22009, I think that's the expedited procedure that's going to be approached. Is that what you got from it, Don, when you looked it up? Are you taking a look at it?
All right. No, I was muted. Yeah,
Oh.
that's what I got.
I was like,
right.
I'm still here.
No, I was just looking it up and like, yeah, the rule change is very simple. It in Rule 26, the proposed rule change, it's just under Rule 26, signing pleadings, motions, and other documents, representations to the court, sanctions. And it just says under signature, generally every pleading, written motion, and another document filed with the court or served must be signed by at least one attorney of record in the attorney's name or by a party personally if the party is self-represented. And then here's the added language: the signature may be executed electronically.
That's a proposed rule.
That's
But
it.
they're already
Yeah.
accepting them. That's the thing.
Yeah.
They're widely, I mean, I haven't had any issues over the counter or doing it electronically. But I think after this meeting with the board, somebody will attend and find out, what is going on regarding that relating to LPs and document preparers. I think Don, we could get that information out to everybody so they know what occurred at the board meeting coming up on Monday.
Right.
Okay. Now that's all I have because I'm just giving a general overview of e-filing because you could really dig into this because there's all different kinds of, areas of the law and stuff like that. I just wanted to give a quick overview, but there was something else I wanted to bring up as that I think that could be helpful to anyone that's not already doing it. And we have a rule in family court 14A and B. And that rule, I believe, changed in 2019. And what it did was it narrowed down what documents actually required notary. And just off the top of my head, they're like an acceptance of service, an application for default, stipulations regarding child support and custody, I believe, and consent decrees. But in 2020, when the pandemic was first coming about, there was an administrative order that came out from the Arizona Supreme Court that waived the notary requirement on those 4 documents. And so I have that administrative order too, if anyone wants to use it. And we've been dealing with that over the last couple of years. Initially, we had, some judges would accept it and then we'd run into a problem. Like on a default, they'd think there was something wrong with the acceptance because there was a signature and a copy of the driver's license, which is what's under this administrative rule. It's specifically states it's ordered that the courts may accept for filing any of the documents identified under Rule 14A Rules of Family Law Procedure without notarization if they are accompanied by a photocopy of the filer's driver's license and other government-issued identification card. So in the beginning, for a while, we did that, but we did have some issues. We even had an issue on an agreement where a judge was not happy with it and made us get the notarized signatures. So in an abundance of caution, so we don't run into those issues, we started having documents notarized again so we weren't having a problem. What I learned a few months ago is Judge McMurdy is also going to be proposing a rule to make that permanent, where those documents will continue to be, you can sign or DocuSign and provide a copy of your driver's license. So I took a look at it again because I heard attorneys were doing it and getting them through, and I've been doing it on consent decrees. I still am cautious on acceptances and applications for default, but on consent decrees, what I do is we contact the judge's office to see if they accept. And I have like this running list of who accepts it and who doesn't. Most of the judges accept it. And I wouldn't want to provide that list because you never know if you're getting misinformation, or I think you should get it straight from the judicial assistant or whoever can answer that question from the judge's office. But we found it to be a very convenient thing for our clients because they are DocuSigning. When they're ready to do a consent decree, they can DocuSign and provide copies of their driver's license. One of the things in the proposed rule that I think they're going to be addressing in May to try to get it out there, hopefully, is the issue. There has been some issues with people not wanting to provide their driver's license information because it becomes public record. And that's one of the things they're going to, it says in here that they can redact their protected address. Applicant may redact a protected address from the driver's license or other government issued identification card. The rule's I think they're going to propose it to be more specific on that, where either you're going to be able to file a copy of the driver's license as a restricted filing. So it'd be separate where the court can see it, but it's not public record. Or you would still have the option to notarize if you don't even want to go down that route. But that rule is coming in the near future, and it sounds like it's going to become, a permanent thing. So that's why I started reaching out again. I started to just say, okay, let's check with the judge's office to see if they'll accept this, and a lot of them do. I've found one so far that's a hard no, and we actually needed a DocuSign from a guy that was on a ship. We filed a motion, and he granted it. So even a judge. I only know one that's a definite no. In a particular situation, if I guess the judge agrees that it's, the only way that it can be signed, you can get an order potentially saying that you can do that. Is anybody else using DocuSign right now? I think it kind of, with all the changes we've had in the last 2 years, and I think it's one of the better things that have happened in the last 2 years, and I think it was pushed by everything, things needing to be remote and because we had a pandemic going on. Is there anything, I think the e-filing, the DocuSign, the rules changing, I think it's putting us to make things, I think, work a lot better, easier. There's not this required notary on all these different documents. And now we, for our petitions and our responses, we quote the rule, the family law rule, pursuant to Rule 14, that under penalty of perjury, that this following is true. So we don't have our clients notarize, have their signatures notarized on petitions and responses, and they can literally DocuSign them, and we file them with the court, and we've been doing it for several months and not had any issues. I just wanted to put that out there because I am not aware of anything that would cause a problem when we haven't had any problems with it. Now, that's primarily in Maricopa County. Pinal County, you still have to go by their rules. Yavapai, Yavapai is really wanting to see the slash as slash, and I think it's because of the administrative order. But they are extremely easy to work with. Yavapai is great. Anyways, I don't know if anybody has anything else to put out there. I thought maybe that could be relevant to what we were talking about regarding e-filing. I don't want to go too deep into e-filing either, in case I want to see what's going to happen at the board on Monday and what they're going to be specifically talking about, and if there's any issues with how doc preps or LPs do e-filings for their clients. I don't know if it would be restricted to they each have to have their own account or how that would work. And it is something that if it is restricted to just having one account, I would like to try to get something out there through the Family Court Commission, the Family Court Improvement Committee, to see if there's something that could be changed there, so it wouldn't put a burden on people that are assisting self-represented people, which is, as you know, a high amount of people in the courts and family court. But does anybody have anything to add to that?
Well, and as you pointed out, there's you can have a business account, so I can't imagine what else the business account is for. If you're not going to be able to, well, I can imagine other things, I guess, but that certainly could be one use of the business account, to be able to file your clients' cases for them. So
Sure.
they don't each have to have an individual account. What are the problems that you see or inconveniences with having to do an account for each person?
Time. Just
Okay.
having to take the time, or having the client set them up themselves, which could be, I've got questions, I've got problems. I mean, they have problems opening up ECR accounts all the time. Just more things that take away your time from getting high volume of cases done. That for us, we've had so many cases that all these interruptions just drive me crazy, that we have to stop, put out fires, take care of problems, misinformation, all that stuff, when we've got a lot of work to do. So, that's just another thing you have to deal with that would cause more time. I would assume on setting up the account, as far as saying like a business and not being clear exactly on what that business is, it could be the providers for the parenting class, process servers, but they all sign their own stuff. It's not the self-represented people signing their own documents that are for them, a petition, motion, whatever it is. Those other types of businesses, and those are the ones that come to mind for me, is they're signing on their own behalf because they're the provider for the parenting class, or they're the process server that's doing the serve.
Right. Well, it'll be interesting to hear if there are issues with that, and if so, what the concerns are, because
yeah,
fortunately, there are examples, specific examples of non-attorneys being able to, access accounts, maintain accounts, on behalf of third parties. For example, like with the Corporation Commission, and this is a change in the last year, but up until, I don't know, a few months ago, you could go on the Corporation Commission website and just using your own account, you could access other people's accounts and do amendments, for example, to articles, or change, update addresses, change the statutory agent. But then recently, I can't remember exactly when this happened, 8 months ago, 6 months ago, the Corporation Commission put in some safeguards where the owner of the account of the LLC, a principal, had to invite you or authorize you, a third party, to be able to access and make changes through the website. And I'm just bringing that up just because I'm just saying there are ways, that I guess, security that can be put in place, just to make sure that someone has authority to access somebody's account.
Well, we haven't had any issues with filing LLCs. That's one of the services we provide. and we do it through our own account, and we work directly with staff.
I'm relating it to family law or to e-filing with the court.
Okay.
I'm just saying that there are different things that can be done if there are concerns about security or authorization or what have you, and they could get creative on that, where there's some kind of additional document that if you're filing on your business account, like with the IRS, if you're getting a tax ID number for someone and you're a third-party designee, you just have to answer a couple questions to say that you have authority to do that, and you're required to, maintain, kind of put in your records, the authority that you had, the application, and then just a separate document that says that they granted you authority. Am I making sense? I'm just saying that if there are some concerns, I think there are good, there are good examples out there of in related industries, legal type matters where technology has accommodated reality.
Right.
So, but yeah, I would love to hear if anybody else in attendance today is doing any of this type of e-filing, especially if you're in a different county, what your experiences are there, or what you hear is going on in other counties, if it differs from what Kelly has talked about today. If anybody wants to raise their hand or put something in the chat, that would be helpful. But I know this is a new thing, so I don't have a feel for how many people are doing this or not.
We have filed in Pinal County and Yavapai County, and they're completely different. It really does depend on the county.
Yeah, hopefully there'll be some uniformity, at some point about these things. So, okay. So I'm sorry to interrupt you, Kelly. Anything else that you wanted to go over today? That's
all I have, unless anyone has any questions. And I was going to say that if anyone has a question I can't answer, I will find the answer for you. If there's something you're unsure of, or you want to know how something works, I can get that information to you if that's what you want. If you're requesting.
And I think it's good. I think it's, it's fine that there's not, I see a couple comments in the chat that, people aren't doing these, aren't utilizing e-filing yet. And I think that's, I think it's good that we're a little ahead of it. I appreciate, Kelly, you pointing out where people can go to educate themselves about using the systems, and it's amazing how much is out there. That the court has provided to educate us about how to use those systems.
And resources. There's people you can call that can help you as well.
Yeah.
And I'll provide all that stuff to you.
Okay. And yeah, I mean, it makes sense. That it does make things easier on the court. Keeps traffic down, streamlines various processes. So I think it's a very good thing.
One more thing I do have to say, when I was trying to reach out to get information from different places and people, I asked anyone that's doing e-filings, at least in family court, I'm assuming it's going into other areas, but the last couple of weeks, they have been so far behind. E-filings usually are posted within a day or two, and they're faster than filing over the counter. The last couple of weeks is the most behind I've ever seen the court docket, especially with e-filing, and over the counters are posting before e-filing. So I asked one of the e-filing clerks when I called in, I was just like, I'm just curious what's going on. And she says, oh, we've been struggling so bad. This is in Maricopa County. They said that they had people that passed away, people that retired, and they are very understaffed right now, and they're working hard on hiring and training people. I did see towards the end of this week it picking up a little bit, but I even heard from a judge's office they were taking the judge's staff filing something at one point was taking 10 days to post to the docket, but that was why. And I for anyone that is experiencing that, I just wanted to put that information out there because I feel like when you have the information, you're more patient and understanding of what's going on and knowing that everybody's going through it. So I just wanted to put that out there.
Absolutely. Okay. All right. Well, anything else, Kelly?
That's all I have.
Okay. Well, Kelly, thank you so much. Great information, information all of us can use to, to better our business and make life easier for us. So, all right. Well, thank you, Kelly. I have to do my applause. So there's my applause for you. I don't know if you can see that.
Okay.
But okay. All right. So I think and there's people in the chat that are saying thank you. Oh, and there's a Lupita says she's in Pima County and would like to know what's going on in regards to training for LDPs. Lupita, do you mean training in regards to e-filing, or do you mean just CE classes in general? And you're welcome to unmute yourself if you wanted to talk, or you're talking about e-filing. Okay. Well, I think and again, I'll be sending these, forwarding the handouts with the links that Kelly provides me when I send everybody their certificates. But the training really is not just on the Maricopa County side. It's really on the Supreme Court website. Isn't that right, Kelly?
Yeah. That link
so,
that I showed, let me go back to it.
Okay.
And I'll provide this to everyone. This is where you first go. And then you go into the e-filing, which brings up this screen, and that's for the whole state. Now, the administrative order that I'll provide as well, that regarding e-filing, it also states that presiding judges of the superior courts in each county can come out with their own administrative orders too. I checked Maricopa and didn't find anything, but I didn't look for Yavapai, Pima, or Pinal County. But this and the AOC support is the one that told me this is like the best resource. And if you have the time, and I wish I had the time, I would have signed up for one of these live webinars so I could have learned more. But as I learn more, or if anyone has questions and they want to just reach out to Don, I'm glad to find out that information for you.
Okay, great. Yeah, I'm definitely going to take those courses that are available, the online trainings, just because I feel like I definitely want to know more about it. It just makes business so much easier if you can do that, utilizing that technology. So, but also, what's that?
Absolutely.
Yeah.
That's what I love about all this stuff is how it speeds things up and is more convenient for not only your clients, but for you as well.
Right. Okay. All right. Well, thank you very much, Kelly. And so, and thank you everyone for listening and contributing. We appreciate that. So I'm going to move on. I think there's two other topics left. The longer topic, which I'm going over today, is on alternative dispute resolution and family court conferences. And so I'm going to start on that one next. And I think we'll do the ethics part last. Now, we have covered some ethics today, as part of the two presentations. And so although I do have an ethics hour planned for the last hour, but if we're a little late getting into that or a little early, I think it works out either way. All right. So before I start the next presentation, I'm going to take a minute I got to unspotlight Kelly and bring that back to myself. And then also, I want to go ahead and hold up the second verification word today. And so the second verification word is grass. So make sure you write the word down. Remember, there's 3 words total. At the end of the webinar, please email me the verification words, and I will respond with your certificate of completion, as well as the handouts that we have from the presentations today. So everybody get that hold that close. All right. I'm appreciative and amazed about how little problems we have with the verification words. Every once in a while, someone misses it, I think, but for the most part, everybody does really good on writing those down. So far, I haven't been called on it. Nobody from the court has said, "Hey, I want you to verify that this person attended." But at least we have some, obviously the reason I do that is so, it's at least one way of verifying that someone attended the class for the most part. And I think that's what the court wants. And I don't have the technological know-how to just embed that somehow into what we're doing. But I'm sure it's probably not too difficult, but beyond me right now. So, all right. So Kelly, let me, while I'm doing this, if anybody needs to take a 2-minute break, by all means do so, but I'm getting set up for the next part, and then we'll go from there.
Don, do I need to do anything on my end? Like it says stop spotlighting me. I didn't know if I needed to click on that.
Oh, that's what I'm gonna do right now. Stop spotlighting. Okay. All right. So bear with me, almost set up, and we'll get it going. Okay, everybody ready? Ready, set, go. We'll get started with the next presentation. And this presentation is scheduled to last for a couple hours. We may take a brief break after an hour, depending on how we're moving through it. All right, so as I think most of you know, my name is Don Stewart. I'm going to be presenting now on alternative dispute resolution and family court conferences. So let's talk about the agenda for this part of the presentation. I'm going to talk about myself for a minute. I'll get to that. And then we're going to talk about alternative dispute resolution, defined, benefits of ADR, types of ADR. We're going to talk about about conciliation conferences in the court, mediations in the court, open negotiations. I'm going to go over a topic that most of you may not be too familiar with, but have heard of if you do family law, and that is settlement conferences. I'm sorry, parenting conferences. I'll also go over settlement conference, but parenting conferences. And then we'll briefly go over early resolution conferences, options or resources in the Family Conference Center, the services that they offer. And so we're going to cover a lot of alternative ADR type services that your clients can take advantage of, and maybe how you can help them do so. So let's see. Well, let's start off. I just want to tell you about my background and my knowledge and expertise in this. I've been a certified legal document preparer since the inception of the program back in 2003. And prior to that, I worked as those of you around prior to that time, we called ourselves independent paralegals, and I worked as an independent paralegal since about 1992 or so. And I have a lot of experience in family law. I've done several, probably 2,000 or 3,000 divorce or family court related matters over the years. And now, in about 6 years ago, I sold the business that I had run for many years, and I went for work for the Superior Court as a court conciliator. And I should probably do a big disclaimer here that everything I talk about here is, for educational purposes only, has nothing to do with the court. I'm here just on my own talking about these topics. But I do currently work as a court conciliator in conciliation services. It'd probably be relevant to say that I have a background in psychology. I have a master's degree in community counseling. And I also, back when I had my previous doc prep business, I went through probably around 2008 or so. I decided to go through the Attorney General's training, mediation training that they offered at the time. And I started volunteering with the Justice Court, doing mediations, and then incorporated that into my business. I also went through a private training for family law mediation at right around the same time. Both of them are 40-hour trainings, and started doing some family court related mediations when I was still running my doc prep business. And so, that's kind of the background that helped me, after I sold my business, get into working for the court as a court conciliator. And so I have, a lot of experience since I've worked for the court. I've done, hundreds of, conciliations, mediations, open negotiations, parenting conferences, and so I'm going to draw from those experiences in the presentation today. So that is me. Let's just jump right in and start talking about alternative dispute resolution, ADR. So as many of you are aware, ADR is kind of an umbrella term for, a broad scope of dispute resolution methods, both private as well as court connected. And they're designed to help parties resolve their conflict without going to trial. That's the main idea there, and there are a number of benefits that I'll talk about in a minute. I do want to mention too that the Arizona Revised Statutes of Rules, Family Law Procedure, Rule 66 specifically, it encourages parties to use non-adversarial means of ADR to the greatest extent possible, whether through a program overseen and administered or authorized by the court, or by a person or agency that's independent of the court. And as we'll see when I talk about the various types of ADR that your clients can use, they're offered publicly and privately. Again, parties are encouraged to participate in mediation and other ADR separate, or to avoid having to go through any type of litigation if at all possible. So what are some types of alternative dispute resolution? And some of these I'm not going to go into in any meaningful detail, because they probably don't involve most of us. But here are, some of the major ones. Certainly, and this is primarily what you see some attorneys doing nowadays: collaborative law process. Collaborative family law is kind of an alternative, is an alternative dispute resolution process, where the litigant, or where the litigants, with the parties, say if it's family law, the spouses work together to resolve whatever legal issues there are out of court with the help of their collaborative family lawyers. And they'll often bring in other professionals to help with that process, whether it be accountants or realtors or just other experts that might help with the collaborative process. But the idea is to avoid going to court. In fact, I'm not that familiar with the agreements they enter into, but my understanding is that if they have to not go to court, until they have an agreement, or if they go to court, then that process ends. And I think that they have to hire different attorneys if they're going to use attorneys to proceed on to court if they exit the collaborative process. Again, that's really all I'll talk about. And as far as that goes, there's family law arbitration, there's private mediation, and there, Family Court Rule 67.3 talks about that. There's actually a list of private mediators that you'll find on the court website that you can refer people to. There's settlement conferences is another form of ADR that I will talk about. And then, primarily my focus today will be talking about conciliation court services under Rule 68. And then I will also talk about the early resolution conference. And then there's one, I guess I didn't put on this list. I'll talk about other ADR as it relates to enforcement actions like enforcing child support, parenting time, medical expenses, division, or enforcing carrying medical insurance, all those kind of things, which utilize, at least attempt to utilize a form of ADR before they're sent to a judge, before they go to any kind of litigation. So what are some of the primary benefits that you see in using ADR? I think one of the biggest benefits is definitely empowerment. So parties are empowered to decide for themselves whether and how they would like to resolve a situation, and are not just subjecting themselves to whatever a judge or commissioner or whatever, some other authority that can make the decision for them. Speed. There's certainly if people utilizing ADR, you're going to see things done generally much quicker. So it's certainly quicker to go to mediation, by way of example, and negotiate or mediate the issues surrounding a parenting plan, let's say, than it is to just fully litigate something. And so that kind of spills over. A lot of these are all interrelated, these reasons, but there are economic benefits in resolving or narrowing issues or disputes through mediation. For example, parties can save an enormous amount of time, energy, expenses associated with some, protracted or conflict and litigation. And now this next one, I want to comment on confidentiality. That doesn't apply to all forms of ADR. There are non-confidential ADR, but confidentiality can be a big reason, a big benefit for entering, for utilizing ADR. And I'll talk about that more a little bit later when I talk about specific forms of ADR. And then the quality of the settlement. Studies on the matter indicate that parties entering into voluntary agreements through ADR are far more likely to adhere to and fulfill the commitments made in such agreements than they are with judicially imposed resolutions. And then finally, I think ADR is a great option to avoid a bad outcome. Through ADR, like mediation, parties avoid the kind of win-lose outcomes associated with litigation. And not always, but it's a perception that I see in my experience that people come out of mediation, for example, or other forms of ADR, feeling that they've kind of avoided that those feelings, those labels associated with more traditionally associated with litigation. And it's also ADR, one of the things that we review with people in mediations or open negotiations or other types of conferences that are ADR related is the concept of BATNA, which is kind of defined as the best alternative to a negotiated settlement. So you're constantly kind of you may be specifically asking or or encouraging people to consider the alternative to a negotiated agreement. What happens if there's no solution reached? And the answer to that question is usually you have to go to through the headache, the time, the expense, and other kind of negative factors in litigating a matter. So those are great benefits to ADR. When might ADR not be appropriate? These are a few examples. Certainly the biggest one would be when there's been a recent or some continuing domestic violence involving the parties. Now that doesn't always exclude people from ADR, but certainly there is that's a big issue with people not being able to participate if there's continuing domestic violence and people are intimidated in certain ways or afraid or feel they'll get retaliated against. Which the next on my list when a party fears retaliation personally or against another. So a question sometimes I will ask is there any reason that you feel that you wouldn't be able to meaningfully participate in an open negotiation or a mediation for fear of retaliation, not just against yourself, but also maybe against your children, so based upon what you say. So during, if it's pretty clear that, a party's going to say something negative about the other party during the conference, and they might fear that, their child would be penalized or somehow punished based upon what the party said during the conference. And so those are issues in most, as I'll talk about in a few minutes, with most of the conferences that I run, I'm going to ask people about these issues, and if this is something where someone doesn't feel like they can meaningfully participate in a conference, then the conference may be deemed inappropriate or avoided altogether in the first place. Next on my list, where one or both parties are not mentally competent or lack the ability to participate in ADR, for whatever reason, a party doesn't understand the issues, isn't really skilled or capable of negotiating. I know with some private mediators, they may screen for this sort of thing, and they may engage in some coaching with one or both parties, so they can better participate in the mediation process. And not something that I have done, but that's something I hear from some mediators, private mediators, that they do. And then finally, where one party refuses to follow ground rules in ADR. So as I'll talk about in a little bit, it's a best practice to set up certain ground rules in any kind of a conference that you're conducting, and where people are, and I'll talk about what those ground rules typically are in a little bit, but where people are repeatedly violating those ground rules and just making the process unbearable, or they're unprepared. And I guess you could say also where people that are in the mediation are not really the decision makers, and that would be more of in civil mediation or other types of mediation. Those can be reasons that mediation might not be appropriate for these parties. Okay. So let's start to talk about, and by the way, I'm kind of going back and forth. When I have my screen up, I can't see all of you, so I'm checking every once in a while to see if anybody has a question or comment. And by the way, as always, I absolutely, I think I do have a question. Let's see. I definitely, so Kelly, you had a question?
Yeah, do you have any suggestions for if you have a client that is having mental problems and they're wanting to go to mediation?
Okay, so you're saying that you, in your opinion,
Or
at
is it,
least, this person is not competent to participate in
yeah,
mediation?
they are very confused. They don't understand what they're doing. We're not experts, but you suspect there's a serious mental issue. I guess there's really nothing we can do because we are just there to prepare and file the documents. But this is something one of our other paralegals experienced recently, and they were wanting to do mediation when they were proceeding towards a default, and it was a very uncomfortable situation of not exactly knowing what to do. But I think the paralegal just filed for mediation to see what's going to happen. But I didn't know if you had any suggestions for if you think someone has a, they're just not competent to go through something like this. I know
Yeah.
this is something the courts are looking at too, just in general, like if a judge has an issue, what to do with it, and they're coming up with ways to deal with it. But I was just wondering, with your experience, if you had any thoughts on that.
Yeah, I would say that that's a difficult issue. I don't know how that would be screened ahead of time, and then even when, if, parties were, if that person were in some type of a conference, um, whether it be a confidential, non-confidential conference, I don't know. Yeah, it would be, just because, that it is a tough issue because, okay, just because they have some mental health issues, I don't know that that should definitely disqualify them or make mediation appropriate. If they're, yeah, I mean that there's a differential in power and ability. Um, yeah, that's a tough question. I don't have a good answer for you. I actually don't. I mean, I certainly have conducted conferences with parties that certainly didn't seem to be the most mentally healthy or together people. However, that doesn't mean that they didn't enter into a fair, reasonable, and knowingly enter into a, in agreement, or I don't know that they were in any way abused by by being subjected to participating in that process. It's a very good question. But yeah, if I knew something, like sometimes this isn't the same thing you're talking about, but I have had situations where people have informed me that they didn't feel they were capable of participating because of things that were going on in their lives, and this isn't the exact scenario, but let's say, someone's parent just died and they're standing in the hospital and they, and they're just, not, and they're emotionally devastated. And I think I have the discretion to determine that it's not appropriate to do, because that person can't meaningfully is telling me that they can't meaningfully participate in the proceedings. And so I'm gonna accept that for what they say. I don't know if that helps at all, but yeah, but yeah, just it's a unless someone has really been deemed incompetent, I don't know how they can be excluded from participating in that process if they want to.
Thank you.
Okay, did that answer your question to some extent?
It does, but I know it's a difficult question. It's just something we had happen recently that was a really unusual situation that we hadn't come across.
Yeah, yeah, but yeah, like I said, I don't. I don't, unless they're really, incompetent. I don't know that I don't even know that they should be discouraged from wanting to participate. Yeah, it is a tough issue, and it's very circumstantial. It depends on what's going on. But okay, so let me see if I can. And I will try to, hey, Kelly. Kelly,
Yes.
Okay, if you don't mind, since I am using one screen right now for these things, if you do see a hand come up and or something in the chat that I don't notice, I'd appreciate it if you would alert me to that.
Absolutely.
All right,
And
thank you.
comments as well?
What's that?
Comments as well, or just hands up?
Absolutely.
Okay.
Absolutely. Either one. Yeah.
Will do.
So, all right. So let's see where we're at. So we talked about, we talked about benefits of ADR, types of ADR, when ADR might not be appropriate. Let's jump into talking about of a particular type of ADR, and that is conciliation. Conciliation is something that many of you may not be familiar with, but the purpose of conciliation is really it's really an effort by one or both of the parties to preserve the marriage or resolve certain controversies going on in the marriage, which which ultimately is usually, I think, to kind of streamline the divorce process if that's the case. So when I meet with people for conciliation services, this is basically what I describe to them. I say this is an opportunity to talk about and explore issues, options, and resources that might help you reconcile your marriage. However, if reconciliation is not an option for one or both of you at this point, that conference can also become an opportunity to discuss and possibly resolve issues to help reduce conflict, and maybe streamline that divorce process that you're already engaged in. By the way, just to be clear, and I think I'll talk about this later usually, but a conciliation petition can be filed either prior to anybody filing for divorce or within a certain period of time afterwards, after the petition has been filed. But so anyways, that is the basic objective with a conciliation. But people are informed basically that if that they're going to be having a very frank conversation about the direction individually as well as jointly parties want to take, whether they want to work towards reconciliation, whether they want to just kind of work towards proceeding with a divorce or separation. And then we kind of explore whatever resources options might be available to proceed with those objectives. It's important to note in a conciliation, any agreements that the parties reach are not memorialized by the court. It is a confidential proceeding. It's confidential, meaning that what we talk about there is private and cannot be brought up in any other forum. And that's the case in certain other ADR processes as well. I think the fact that it's confidential makes people often feel a little more comfortable that they can be open and honest, maybe even suggest possible solutions or courses of action they might not otherwise suggest in a non-confidential forum. I also want to mention that what conciliation is not, and there's often confusion about this. Conciliation is not marriage counseling. However, if marriage counseling happens to be something that the parties agree that they're interested in pursuing, then the conciliator or the professional that's conducting the conciliation, usually will can give some direction on how they might want to pursue that, and maybe help develop a plan that they agree between the two of them about how to pursue that. And sometimes that might be a very detailed thing about, the consisting of, okay, by such and such a date, we're each going to find 2 counselors or psychologists or whatever the case may be, and exchange those names and decide by this particular date who we're going to go to. But there may be many other things that they do that will help them pursue reconciliation or not. Now, the role of the conciliator or professional that's conducting the conference is that of an impartial, neutral third party. They're not there to take sides with either party. They're not there to give legal advice to either party or predict outcomes or determine, what any agreements that could come out of the meeting should be or would be. They're really there to facilitate a discussion, try to drive that discussion towards some kind of positive end. I will say conciliations are tough. Out of all the conferences that I have done, the ADRs that I participated in, the conciliations are very difficult because, more often than not, as you can imagine, one person is coming to a conciliation conference desperately wanting to reconcile the marriage, and one person absolutely does not want to reconcile the marriage. I mean, that's probably a common thing, even though they may still care very much for one another. And so, you have people that come to conciliations with letters that they want to read to the other person while they're sitting there. There's often a lot of crying, with at least one person, sometimes the other, as well. And so it can be a very difficult emotional process. Sometimes, and you know what, I almost always, I feel that parties are there for true, legitimate reasons. Sometimes it certainly can be a posturing thing, for the purpose of delaying, the process. But because once somebody files for conciliation, then the proceedings are stayed for up to 60 days. And I think that can be advanced even longer than that, by court order, a little bit longer than that. Off the top of my head, I can't remember how long that can be extended to. But again, it just is a very can be a very emotional meeting. I'll say I don't generally look forward to conducting conciliations sometimes, but at the same time, I think as a professional, I've had some of the most rewarding experiences and sometimes surprising experiences in conducting conciliations. Situations that I'll prepare for that I would never have guessed that parties would walk out of there happy or with a plan to reconcile. And when I say walk out of there happy not only either because they're going to reconcile, they're going to make an attempt at that, or on the alternative, they're not going to reconcile, and that's okay. I think it is a very important service that's offered, and it's a very important experience for many litigants because even if they're not going to make any efforts to reconcile, which they often do not, it's important because it's often a time, and this is just my perception, maybe in a lot of cases, but it's the first time I think a lot of litigants or parties going through divorce or separation or an annulment truly understand that they are getting divorced or separated, or the annulment is proceeding on, whereas they had maybe some very unrealistic hope that it could be that the situation could be reconciled. And so now I want to talk a little bit about, well, since I'm talking about the process, I'll go through the process a little bit more. Typically with conciliations, for me at least, I work them a little different than I do other conferences. I'm not saying every counselor or conciliator or whoever conducts these types of conferences do them the same, but I typically will meet with people separately at first. So we'll have a brief initial meeting, and at that brief initial meeting, I just will tell them what I described to all of you about the purpose and the purpose, my role in the process, that it's confidential, and then I will meet with them separately. Now, before pre-COVID, of course, these were in-person meetings. Since COVID, I do these conferences remotely, usually, not always, but usually by video conference. I have done many of them even telephonically, which may sound odd, but when there was a time during COVID that I had to do them telephonically, I wasn't so sure about how that process would go, but surprisingly, I really didn't see much of a meaningful difference between the outcomes and the way that they proceeded, which again may sound surprising to some of you, but that's just the way it went. So when meeting with people, the conciliator or the professional, when meeting individually, basically, you're talking about open-ended questions that start off with basically, what are your thoughts for or against reconciling the marriage? And you kind of go from there. And people typically will open up about their thoughts, talk about, what they've done to date, if they've done counseling, what they, what, kind of, usually there's some storytelling about kind of how they got to where they are at that point. And then kind of go from there. And the people usually quickly express, what their intent is, what their willingness is to explore reconciliation or not. And then if the answer is not, then it moves to exploring, what other issues are going on, what could, make that process go a little more smoothly, reduce conflict between the two of them as they go through that process. Other, issues, certainly, especially because of in some cases, extreme emotion that's going on. Well, I think it's wise to talk about, ask about what their resources are, what their support systems are, to make sure, to do the best that you can to make sure that they're taking care of themselves, that they can, that they're going to get through that process okay. And also asking each party what those same questions about the other person, the question, have you considered the possibility that your spouse is not going to want to reconcile? Or on the flip side, what do you think about your spouse? What do you think about them wanting to reconcile? So you go through that process, talk of, and to some extent it is kind of preparing them to be able to present themselves to the other person when we have a joint session. So anyways, those separate meetings might last 20 to 40 to sometimes longer, sometimes 60 minutes with each party. Usually I'd say closer to like, half hour or 40 minutes. And then if it's appropriate, meet jointly. And at that joint session, there are ground rules set up. Ground rules, very simple, but very important. Only one person speaks at a time. Don't interrupt the other person, even if it takes a long time, even if you think what they're saying is a lie or untrue or however you want to characterize it. I usually ask people to refrain from any personal attacks on one another. However, recognizing that, people are there usually because something has gone wrong, something's not going right, and you need to talk about that. Certainly you can do that, but people are encouraged to talk about those things, those high conflict issues in such a way that they're kind of looking for solutions and not just for the purpose of beating each other over the head with the issue, which many people will happily do, as long as they're able to. Anyways, there are certainly many times when parties do not meet together. There are many times that people don't feel comfortable meeting jointly with the other person, and so those situations need to be dealt with accordingly. I want to show you what. Let's see. I'm going to try to share with you the typical. Let's see. So, Kelly, can you see the instructions that I have up on the screen?
I can, and also there was someone that raised their hand.
Oh, I'm sorry. Okay, Kim. Yes, you had a question.
Oops.
Kim, if you're talking, I can't hear you. Or was that just an accident? You put your hand up. See, okay, maybe that was an accident. All right. So, all right. So, you can access the petition for conciliation services is very simple to fill out. You can I think that I don't see why anybody would need anything more than what they're offering on to download off the Maricopa County Self-Help Center website. And it gives good instructions on how to fill out the very, very simple form. It does give some good information, as I mentioned earlier. It talks about who can use the packet. It says if a petition for dissolution, legal separation, or annulment has been filed, and the petition for conciliation services is filed within 60 days of the petition, there will be a hold or stay on the proceedings for up to 60 days. Let's see. The other factor is, I think, they'll look to see if you filed a similar petition within the previous year, and if so, I don't know that you can utilize that process at that time if you've already filed within the previous year. Yeah, here it is. Yeah, if the petition has been filed by either party within the previous year, the proceeding will not be put on hold. So I don't think that doesn't mean I don't think that means that you can't do the conciliation, but you're not going to have the stay. So that's instructions. I'm going to show you the form. Again, form's pretty simple. It just who the party is. Controversy or disagreement exists between my spouse and me. The help of the court is requested to effect reconciliation or an amicable settlement of the controversy. I fully understand this petition may not be withdrawn from conciliation services until the minimum required conferences have been concluded. I'll tell you that is certainly a topic of conversation during conciliations, is that people are often very unhappy about having everything put on hold. And there is sometimes, accusations that the other party is just looking to delay things. And then just talks about whether something's been filed, an underlying petition has been filed for dissolution, annulment, legal separation. And then it gives the, contact information for each party. Actually, I noticed that, one thing in this day and age that is missing off of this that I'm going to see if I can talk to somebody about getting it on there is the email address. There is an email address place up here for whoever's filing, but it doesn't, unless I'm missing something, it doesn't have an email address for the other party. Now, procedurally, when these things are set up, so you have a petitioner or usually it's the respondent. Yeah, obviously most of the time, somebody files for divorce, the other party files for a petition for conciliation services, and then that gets calendared. And once it's calendared, the court processes that since COVID, since all the conferences are still remote, and nowadays all the conciliators are utilizing Microsoft Teams, and so a calendar invite will go out to the parties, and along with just some information about what's going on, and then so they can, with a link to the conference at the date and time that's been scheduled, that they've been ordered to appear. And so, they'll join, and then, as I mentioned before, it's all done remotely by video conference. Many times, one party will appear by video conference, one party will appear telephonically in Teams, which is an option they have. But all right, so this, just to show you copies of some of the forms that are available. Any questions or comments about conciliation services? Any of you refer your clients or have had your clients go to conciliation to try to reconcile or resolve disputes or anything? Curious if any of you have what their experiences have been in that regard. So if anybody has any comments, please let me, put it in the chat or raise your hand, and I would love to hear that. So to move on, so that's conciliation services. So let's now talk a little bit about mediation. Oh, by the way, before the only other thing I was going to mention, I have on my list here the obligation to participate. I mean, it's a court order. They're ordered to participate. However, right now, the orders to appear, I don't think they generally have any consequences for failing to appear, in terms of any fine or that's written into the order. But I wanted to mention that because that is not the case with mediation. So let's talk about mediation services. Now, mediation, of course, you can utilize mediation either through a private mediator or through conciliation services. And I'm going to talk about my view on some of the differences with court versus private mediation in a minute. But so so the purpose of mediation is basically to try to help disputing parties find some kind of a mutually acceptable solution to whatever issues or problems they might be having. And in the court orders mediation, in some cases, and you see mediation provisions in most parenting plans as being kind of a part of the required process when they're wanting to change something. Primarily to give parties an opportunity, a forum or a place to communicate and hopefully reach some kind of a voluntary agreement as it relates to parenting time and legal decision-making issues. And to be clear, it's important to know that mediation with the court, at least, can only be used for parenting time or legal decision-making issues. Mediation, they cannot deal. The mediators cannot deal with any financial issues in this type of mediation. Now, that's different than conference officers, and I'll talk about that a little bit later. But they're not really doing ADR, but it's not the same as mediation. Anyways, point is that in mediations with the court, you can only address legal decision making and parenting time issues. Now, as I've kind of discussed before, you want to be in mediation. Parties, your clients, want to be in mediation because it's their opportunity to keep control of the court orders and not just leave everything in the hands of whatever the judge might decide to do. And when I say that, I'm not intending to disparage a judge in any way, but the reality is that in most cases, not every case, but in most cases, the parties involved know what's going on in their lives. They know what's going on with their children, probably much better than the court does. And the court recognizes that and wants to give parties every opportunity to keep control of those orders, to craft those orders the way they see fit. And so they, by going to mediation, they can do just that. Now, mediation, like conciliation, mediation is confidential. Again, meaning what happens in mediation, kind of like the old Vegas thing. What happens in Vegas stays in Vegas. What happens in mediation stays in mediation, and cannot really be shared in any other forum. I guess the only exception, and this is, I think, kind of across the board for confidential type conferences, would be if there was something going on that was revealed during the conference, regarding, like, let's say, child abuse, for example. That's something that does not remain confidential, and conciliators, and I think counselors and psychologists, I think they're probably be mandatory reporters and would have to report something like that, which certainly can come up during a mediation. So anyways, it's confidential. Just like with conciliation, in mediations, the mediator, their role is that of an impartial, neutral third party. Again, they're not there to take sides with anybody. They're not there to give legal advice or anticipate who'd prevail on this issue or that issue. It is facilitated mediation. And so, we're neutral in all those respects. Now, at the same time, and I guess this goes also for conciliation, certainly on occasion, a mediator, conciliator may give or offer suggestions or possible courses of action that parties may want to consider to address whatever issues that they're bringing up. However, it's perfectly fine if the parties reject whatever those suggestions are, because then in the end, it's their agreement. It's if they're able to come to an agreement. Now, filing for mediation, again, is a very simple process. Excuse me. And there are forums on the court self-help website that I'll show you briefly. So there's pre-decree mediation. Now, pre-decree mediation, in my experience, I don't see many people that are in at court at conciliation services mediation that have self-petitioned. In my experience, more often those people would be referred by a judge, maybe during a hearing of some sort. But there are forums where people can do that. People can file for mediation pre-decree, or certainly you can go to a private mediator to do that. The forms, let's see, people, and I don't see this too often, but I certainly do see it. You can do a joint request for pre-decree mediation. And these forms are fairly, similar, whether it's pre-decree or post-decree mediation. But you can have a joint petition, and you just basically, it's a very simple form, just names and addresses, and whether or not there's some litigation pending. And even with pre-decree mediation, you have to have something pending. At least that's my understanding, whether it be divorce, separation, or some kind of paternity-related matter. And then they simply just very briefly put what it is they're disagreeing about. Whether it be legal decision-making, parenting time, both, or some subset of those issues. And then, that petition is filed with the court. In the case of, and then the court, typically at conciliation services at the filing counter, they will generate an order to appear for you. And then it just has to be served on the other party like anything else, whether that be through sheriff or marshal, private process server, certified mail, you could do that. And then they appear at the hearing. I'll describe how that happens or what that process is in a minute. Get out of that. Let's see. So, so that's how to file, and I think it's important to note that, if you have clients, for the most part, and this is not entirely true, but for the most part, people can file for mediation at any time. So you have clients that have an existing court order, so they have a parenting plan, yeah, and they have some issue that needs to be resolved, whether that be a parenting time issue, a legal decision making issue, and it could be where they do their exchanges. It could be how they organize and arrange for setting up doctor's appointments, or what could be how they communicate, whether they're communicating through email or text or using a parenting app or whatever the case may be. Those things, if rather than just continue to argue about it, or have problems, or not have parenting time, or whatever the consequences of what of the dispute is creating, they can file for mediation anytime. I would say the mediation petition could be denied. I guess there could be reasons I'm not thinking of, but certainly if they just had an order entered and they're wanting to mediate the same issue, I can foresee that the petition could be denied, and I'm sure that happens. Although I've done many mediations for people that have fairly recent court orders, and often it's for issues that just weren't adequately dealt with in the prior court order, or sometimes it is for the same issues, but just there have been a dramatic change in circumstances. So just because the order was recently entered doesn't mean that it's going to be denied for sure. but it is going there's not much to lose. What do you have to lose to going to mediation? There is a fee. There's a $100 fee to file, but people should, consider the fact that it's a confidential process. So if it doesn't work out, okay, it's not there. Whatever said during mediation is confidential. It's not going to be held against people. It's not going to be brought up during a subsequent proceeding if they end up filing a petition for whatever reason, whether it's a petition to modify this or that. Now, the process that we engage in at the court for mediation is similar to what I described with conciliation. It's virtual by Microsoft Teams. Again, just once the appears on the calendar, there's a calendar invite that goes out with links to the conference. And then when that conference started, similar process. It just the purpose is explained, the confidentiality is explained, the ground rules are explained. Same kind of ground rules. Don't talk over each other. Only one person speaks at a time. The things that I mentioned before that are talked about in conciliation, and then now mediation with the court is limited to 2 hours. There was a time in years past where conciliators had an option to maybe continue a hearing to a second meeting. That is not the case at this time. And I think it was rarely used when it was an option. But I would say that is maybe it can be a significant downside to utilizing court mediation. And I say that simply because sometimes there are situations where that's just not enough time. And to conduct the mediation, to put together an agreement, all within that 2 hours. Now, having said that, and this is something maybe to pass along to clients that you may have, mediation is very successful. I would say, and I'm you can't hold me to this, but I would say that there's probably a 50 to 60% success rate in court mediations for people to come to some type of an agreement, whether it be a full agreement or a partial agreement about legal decision making and parenting time issues. That's pretty good. I think that's maybe unexpected. Having said that, in private mediation, I have read, and I've read different reports and studies on this, but it might be as high as 90% of the time that parties enter into agreements through mediation. That's fantastic. Now, obviously, the big differences, I don't know that there's any, and maybe I'm patting myself on the back a little too much here, but I don't know that there's any necessarily a meaningful difference in skill level. I think it has a lot to do with the fact that with private mediation, you certainly have, more time. Sessions could be longer. You can have multiple sessions, and that makes a lot of difference. At the same time, I mentioned, maybe, 50 to 60% success rate where people coming to agreements during mediation through the court. Even for a large segment of those people that maybe don't enter into a partial or full agreement through court mediation, at the same time, there are a large percentage of those people are kind of on the right track to enter an agreement on their own. They may run out of time. There may be a set of reasons that people don't finalize an agreement in court mediation, which can it can be as simple as, hey, I'm all on board on this, but I have an attorney and I'm not going to do this without talking to my attorney. And I'll have a comment on dealing with that in a second, but usually it's more so that something needs to be checked out. Whether, maybe with a third party, maybe with a spouse or significant other, that or just a practical consideration they just don't have the answer to during the mediation. And so that agreement rate, I think, would be much higher if there was a little bit more time or the ability to have multiple sessions. But regardless, I think it's a respectable rate, and certainly it's beneficial, to refer people that if they have problems, if they have issues, they're trying to work out to do that. So how does this all work? So you meet with people in mediation, you conduct the conference, and I'm not going to go to this. This is not I have done sessions before, trainings before in past years in our webinars about how mediation works, but I'm just going to talk about procedure. If parties are able to come to an agreement, then typically, time provided, that agreement will be written up right then and there. And so if it's in person, obviously the agreement is printed out, reviewed with the parties, and then they sign it. And nowadays, since we're doing these things virtually, the agreement is, if the parties are both appearing by video conference, that will be shared on the screen with parties, so everybody can review it together, correct any typos or just errors or misunderstandings that were there. And then once everything looks good, then the agreement is sent to each party via DocuSign. And parties sign the agreement and date it by DocuSign, it automatically comes back to the conciliator, and then the conciliator, generally it comes back to the conciliator, and the conciliator then forwards that through court admin to the appropriate judge to have the judge sign it. Now, if parties are represented by counsel, or if one party at least is represented by counsel, then there is a delay in the signed document being forwarded on to the judge. So what happens is when it's sent through DocuSign, the attorneys are also the attorney or the attorneys are also added to the delivery fields. And so first it goes to the parties. Once both parties sign and date it, then it comes back to the conciliator, and a copy of it goes to the attorneys. And the attorney has 30 days to decide if they're going to object to what was agreed to by the parties. So as you can see, it's not really a while it definitely happens, it's not really it shouldn't be an insurmountable issue that someone's represented by an attorney and they want to have their attorney look at it if the before they would sign it. They can still sign it if they're confident that that's what they wanted to do. They can still sign it, and their attorney still has an opportunity to object over the following 30 days. So during that 30-day time period, it's held and not forwarded to the judge, and then afterwards it's automatically forwarded to the judge. Now, there are 4 cases where attorneys are not involved, and there are some judges now, a handful of judges, where that have signed up for this additional process where when it's sent through DocuSign, the DocuSign is set up through the court so that it will automatically go to the parties for signature, and then automatically after they sign it, go directly to the judge or to that judge's division and given to the judge. And so there's no intermediary a mediator that has to receive it first and then forward it through court admin. It automatically happens. So they're really streamlining these processes, and that's the case also with open negotiations that I'll talk about next. But let's see, I wanted to comment on obligation to participate. There definitely is a consequence. If somebody files for mediation and the other party is served and one or both parties don't show, there is a failure to appear order typically issued that fines the person that doesn't appear. I think it's $200. And so the conciliator will prepare that and send that to the judge, and it's up to the judge to sign either way. And also it deserves comment that for any agreement really that the parties enter into during mediation, it is always up to the judge whether the judge is going to sign it. And I'm sure there are some circumstances where maybe that doesn't happen. I have never had that happen in any case that I've worked on where the parties agreed to something and the judge would not sign what they agreed to, but it certainly is possible. Let's see. I feel like there was something else I wanted to mention about conciliation or mediation, but it's jumped out of my head. I have a note here about MAPS, which are mediation after paternity. So the AG's office has a program where if parties, if they're involved with establishing child support, and the parties, they petition, they typically will bring the parties in to calculate child support. At the time that the child support is calculated and ordered, the parties can stipulate to go to mediation to determine what to determine legal decision making and parenting time. Great program. What's great about it is that it's free. Basically it's just kind of set up. They go see a conciliator. They go through the mediation process. Used to be pre-COVID, there were quite a few of them that came through. Since COVID, I've only seen a couple of them. I don't know why for the vast reduction in the ones that I see coming through the system, but it's a nice thing for people to take advantage of, especially presuming often people that are going through the AG's office to establish child support maybe don't have a lot of resources themselves. So it's a nice thing for them to go through. The only difference between a MAP, a mediation after paternity, and just a regular mediation is that there has to be a full agreement. And this is something that, as opposed to a partial agreement. If there's not a full agreement, there's no agreement. And I didn't mention this with regular mediation. I mentioned that people can come partial agreements, people come full agreements. By the way, if they come to a partial agreement, there is a notation as to categorically what the parties did not agree upon. So let's say they came to a full agreement on parenting time, the weekday, weekend parenting time, the holiday parenting time, but they could not agree on legal decision-making orders. So there's a place on the form that is noted that this categorically is what they didn't agree to. There is not a comment on what their positions were or who didn't agree. Because again, this is a confidential process. So now, if the parties do not come to any agreement, then if there's no agreement at all, then the parties are still asked to sign what's called a notice of no agreement. And the notice of no agreement is kind of a benign form that basically just says, we met, we tried, but we couldn't come in any agreement. It doesn't imply fault on anybody's part, doesn't give any description of what issues they couldn't agree upon. It just says there's no agreement. And it's just primarily for the purpose of just kind of documenting, generally what happened. So I think that is all I was going to say right now about conciliation. Let's see if I have any other notes on that. Okay. The only other thing, and again, this isn't a training on becoming a mediator, but I wanted to just briefly go over styles of mediation in this respect that you'll typically see, not always, but you'll typically see in court mediation or even private mediators are using a facilitative style. So this is just some notes on what that means. So the mediator structures a process to assist the parties in reaching a mutually acceptable solution. I talked about that, and that's done. The conference really involves a lot of open-ended questions. Typically my first question that I would ask is just simply, tell me what's going on from your perspective. Why are we here today? And when you tell me that, maybe give me some, relevant information about kind of how we got to where we are today. So just very open-ended questions, at least starting with open-ended questions, and then, maybe whittling that down to clarifying questions. But the process also, it's important to validate and kind of normalize parties' points of view and their circumstances really in general. I think that's really important for parties because, to know that they're not the only ones going through what they're going through. They're not crazy. It's genuine. Most of the time, at least, it's genuine and foreseeable that parties going through certain circumstances might have trouble coming to an agreement, might have trouble, communicating. And so I think it's very valuable, and it kind of lowers their guard to validate and normalize the circumstances. But facilitated mediation searches for the underlying interests and positions that are taken by the parties. So really getting to the core of what's important to people, and assist the parties in finding and analyzing options for resolution. This says mediators don't make recommendations. I don't know. I think that's a general rule of thumb, but that's not always the case. Sometimes it can be very helpful, but I think it should be kind of a last resort to make specific recommendations. Certainly, we don't give opinion or advice as to the outcome of the case, or predict what the court should do. I went over that. The mediator's in charge of the process, while the parties are in charge of the outcome, and that's made very clear. And I often and sometimes frequently use that BATNA reference, the best alternative, to kind of remind people, okay, what are you going to do? If you don't come to an agreement today, what's the next best alternative? And that is litigating the matter. And we've talked about, the downsides to potentially doing that. Mediators want to ensure the parties come to agreements based upon information and understanding. Mediators predominantly hold joint sessions so that parties can hear each other's point of view, which I think is very important, but hold caucuses as needing. So a caucus would be for a situation where you meet individually with the parties, and when that happens, usually it's for situations where you have a bit of an impasse on issues. And sometimes caucusing with the parties individually can be helpful in revealing underlying interests that, for whatever reason, parties not willing to give up while the other person's sitting there. And sometimes that can facilitate better discussion once we go back into a joint session. Caucuses are confidential between the mediator and the individual meeting separately, except as to matters that the party gives the mediator permission to reveal, if that were if necessary or if helpful. So anyways, I just wanted to briefly show this is kind of a description of the facilitative mediation style. All right, so next, let's talk about open negotiations. So an open negotiation is a process of non-confidential negotiations between parties conducted by a neutral negotiator at the court. That would be a conciliator typically, who attempts to facilitate a resolution of their dispute. So very, very similar to mediation, except it's not confidential, which is a big deal. And so when I talk to people at an intro, the process is really the same as far as setting things up, the same as a conciliation or a mediation. But when we set this up, we talk about the same kind of things, that, to try to find a mutually acceptable solution to problems that they're having. But it's important for them to understand that it is non-confidential. And so really the objective of an open negotiation is twofold: to try to help people resolve their differences and come to an agreement, but also for the conciliator to gather information regarding what issues each of the parties sees as it relates to legal decision making and parenting time issues, and what their position is on those issues. And so ultimately, at the end, the conciliator will write a report that gives the judge assigned to the case, and the parties are sent a copy of this report, a brief background about the parties, about their case. So the brief background might be mostly a procedural thing. For example, the parties were never married. They have 3 children together. This child, by these names and these dates of birth. on such and such a date, petitioner filed a petition to establish legal decision-making and parenting time, child support, asking in part for blah, 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 sole legal decision-making, primary residence, and for the other party to have supervised parenting time. And, just can maybe go through some of the reasons that they brought up, why they're asking for, when the response was filed, what the response said. Again, a little bit of mostly a procedural history. Sometimes I will also insert into the background section some of the things that the parties told me that maybe don't need to go into their explanation of their position, but it would be helpful for the judge to understand kind of how they got to where they are then. Like maybe, and that might include a little bit of a history about their, what they have been doing in terms of parenting time, for example. But the report then talks about the issues that were brought up. So the issues are primarily legal decision-making issues and parenting time issues. So, and then underneath each of those, what their parties' positions are. So, mother is requesting the court or the award the party's joint legal decision-making authority, with mother having final say, and then talking about why. Mother says that historically she has made all the decisions in terms of choosing a doctor and scheduling appointments for the children and taking children to the appointments, and dad has not done any of this, or vice versa, however the case may be. And so for these reasons, she wants to continue to do this, or dad wants sole legal decision making because mom's constantly moving from place to place and can't be contacted, and dad needs to be able to make decisions when issues come up about health, education, or related major legal decisions concerning the children. So you have the intro, the background, you list the issues that people are bringing up. Again, usually it's related to, well, it's always related to legal decision-making and parenting time. Sometimes we might break that down, like if the major issues, the way they communicate, parties aren't communicating at all, or there's, when they do communicate, this, and this happens. And so mom wants to do this, dad wants to do that. So these things go into the report, and those are sent to the judge. Now, nowadays too, there are a few judges that are requiring, in the order to appear at the open negotiation, that are requiring parties to engage in certain activities prior to that open negotiation, where they're told that they should, exchange information about what's good about the other parent, what they like about the other parent, either at the time that they met or currently, or both, and maybe exchanging options or their position on a particular matter and their proposed solutions. So they're better prepared for the open negotiation, and the open negotiation can be a little bit more meaningful for the parties. Now, how do you get an open negotiation scheduled? In my experience, it's almost always something that a judge orders. So you've got a pending litigation, whether that be a pre-decree matter or a post-decree matter. And for whatever reason, the reasons are not always clear to me by looking at the docket or any minute entry orders. They're not always clear to me about how the subject comes up, or why it's being ordered, although I think it's almost always a good thing. But it's usually, the point is it's usually court referred. It's interesting. I until recently, I hadn't really even considered the issue of whether or not someone could just ask for an open negotiation. And recently, I had one where it was just a motion that somebody filed, that an attorney filed. And so so that tells me you can just motion for an open negotiation. Now, why would you want to do that over just doing a mediation? There could be good reasons. Maybe you want to know, you want the judge to know, you think it'd be beneficial for the judge to know about more about the issues. Maybe you don't even expect you're going to come to an agreement. I guess I'm referring to, of course, your clients, and you don't expect you're going to come to an agreement, and so you'd kind of like that little mini report that goes to the judge, that alerts the judge to what's going on, and maybe that might spark some other action by the judge, such as, ordering a child interview, or a court-appointed advisor, or best interest attorney for the children. So, I'm not saying that I don't know one way or another if that is a common, path that happens with open negotiations, but it certainly can be. And let's see how we're doing on time. So we're at 11:23. All right. And by the way, I hope I hope this is interesting to everybody, and not too dry, but if please ask questions. Love to know, again, if you ever get feedback from clients that you have that are in family court matters, that have gone to and utilized some of these services, what their experiences are, whether they've been good experiences, bad experiences, they've worked, they've not worked. Love to hear that. But as you can tell, I'm a big proponent of these ADR services. I think it'd be very helpful. And as I'll talk about in a little bit later, when I get into talking about a parenting conference, I think some of these services, like even open negotiation, I think it can be valuable for especially for non-represented litigants who really maybe aren't so experienced, or maybe even don't even have a clue about how they're going to present evidence and just information as they go through this process. How they're going to introduce that evidence in court. And I think going through an open negotiation, going through a parenting conference that I'll talk about in a little bit, can be extremely helpful for people to kind of get the relevant evidence in that a judge needs to be able to make decisions, particularly when, as we probably all know who do family law, self-represented individuals, or most people in family court, are self-represented and probably don't have a lot of experience or skill in being able to gather the information they need to show the judge or present that information. So open negotiation, while it's relatively simple, there is no commentary or assessment done by the person conducting the open negotiation. It is still just the facts. It's just what the person tells them. But it could be good, important information for the judge to have, and I think ultimately can really help out the people, because it gives judge information that maybe the parties don't have the skill or ability to provide them. Okay, and then now, obviously, as I mentioned before, with an open negotiation, part of the objective, I would even say the primary objective, in my mind, is to try to help facilitate an agreement. And so, if there is an agreement, just like with the conciliation, that agreement is drafted. We're doing this virtually still, so just like just like I described with mediation, shared on the screen, the parties, and then for review, and then it's sent to them via DocuSign to sign and send back. And then both the agreement, whether it be a full agreement or partial agreement, along with the report, is sent to the judge. And so, and then, the judge can sign. It's always up to the judge, but the judge can sign what they agree upon. So any questions or comments about open negotiation? All right, so I will move on. And so the next topic of ADR, or example of ADR, settlement conferences. I actually, in my present work, I don't deal at all with settlement conferences. As a certified legal document preparer, I've helped many people prepare for family court as well as civil, settlement conferences. And this is just kind of a general outline about what it's about. But a settlement conference is another confidential process in which people meet with a neutral, either judge, commissioner, or judge pro tem, to discuss settlement under, pursuant to Rule 67.4. And you can look that up if you're more curious about what's described in there. But it can be a settlement conference, and family court can be initiated by motion from one of the parties, or probably a joint motion as well, or on the court's own motion. Again, I don't claim to know how, when the court orders it, how they decide that it would be a good idea as opposed to other forms of ADR. But I think it's a very it can be a very effective. My feedback that I have gotten from clients over the years that participate in settlement conferences has always been very positive. They don't always come to a full agreement, but it's always been very positive. So who attends would be, of course, the parties, their attorneys if they have any, and really any person the court deems necessary to facilitate settlement of the issues. Prior to attending the settlement conference, typically the court will order a settlement conference memorandum be generated. That's something, of course, that you can prepare for your clients. I don't know how many of you have been involved with those, but this is kind of an outline of what goes into the settlement conference memorandum. And this is very similar, if not exactly, it's not exactly the same, but it's very similar to what you see in a civil settlement conference memorandum. So you have a general description of the issues in dispute, what each party's position is on the issue, what evidence will be presented to support that party's issue. And so, again, the issues, it kind of depends, if it's not a divorce or legal separation, it's probably going to focus just on legal decision making and parenting time. But if it's a divorce or legal separation, it's also going to involve probably proposed divisions of community assets and liabilities. If there's children involved, parenting time, legal decision-making proposal, child support calculations. It states here if there's issues involving financial matters, an affidavit of financial information has to be submitted along with the list of any outstanding debt, who's responsible for the debt, an inventory of the community or joint assets. Some of those same things that you're going to see in the early resolution conference in preparing for something like that. Some of the same similar types of information. Also in the settlement memorandum, there should be a summary of any negotiations that have taken place and just any other information, whatever that may be, that a party thinks might be helpful in reaching a settlement. So my impression, and I haven't read this, but my impression in speaking to people that have attended settlement conferences is that it is the style of facilitation, if you will. I have your styles of mediation evaluative, but the style of facilitation, however the judge might refer to it, is kind of an evaluative style. So and I'm giving you this information so you have a little insight to the way a judge or commissioner or judge pro tem might be approaching the conference, how they deal with and approach the people. So an evaluative mediation is a process modeled on, it says it's a process modeled on settlement conferences held by judges. So the evaluative mediator, who is an expert, in this case the judge or commissioner or judge pro tem, assists the parties in reaching resolution by pointing out really strengths and weaknesses in their cases and predicting what is likely to happen. So this is obviously not the same way a mediator is going to approach the situation. So the evaluative mediator, the judge, or in this case, might make formal or informal recommendations to parties as to the outcomes of the issues. They're concerned, the judges and commissioners are concerned with the legal rights of the parties rather than the needs and interests, and evaluate things based upon legal concepts of fairness, as opposed to the parties' underlying interests. Evaluator mediators meet most often in separate meetings with parties and kind of, engage in shuttle diplomacy. And it is definitely an interesting experience. I have had the opportunity to be in some civil settlement conferences where the judge utilizes this, process of in settlement conferences. But again, I don't know if any of you have had feedback, but I without exception, I've had very positive feedback from litigants that have participated in these types of conferences, and most of the time, not always, but most of the time, they've entered into some type of settlement agreement. So I'm going back and just to finish up the screen, the binding agreements that they enter into as a result of a settlement conference has to be in compliance with a Rule 69, and they are binding. And then, the judge or commissioner or pro tem has to make findings, that I think that you would see just, is similar findings that you would see any other final order, family court order in a similar type of matter, to approve the agreement. So that's settlement conferences. Let's see. I guess I didn't finish there was another screen on evaluative styles, just that they, the judges help the parties and the attorneys evaluate their legal position and the cost benefit elements of pursuing a resolution rather than settling. So in other words, kind of a similar concept as in mediation, what's the best next alternative to settling now? And that's going through litigation. And as I mentioned, I think before, there's an assumption that the person conducting the conference is typically an expert in that area. Okay, so all right, so let's move on to the next. Actually, I think right now I'm going to see. I've done two of the. Oh, I guess I have done the second word, but I think that I want to take just a very brief 2-minute break, and then we're going to get into the discussion on parenting conferences, which is a bit involved, and so I think this would be a good time to take a brief break so everybody can go to the bathroom, get a drink, whatever the case may be, and then we'll proceed with this. Like I said, just like 2 minutes. I'm reading a couple of the comments in the chat, and thank you for your comment, Scott. I hope it's helpful. And Suzette, I appreciate you talking about being a mediator. Would love feedback from you. If you have anything to add about private mediation, would love to hear it. So feel welcome to share if you have any comments or questions. Okay, losing my voice today. All right, so I am back. Hopefully everybody's back from our brief break. And so I want to get into now discussion about parenting conferences. So what is a parenting conference? So a parenting conference is a non-confidential evaluative service, the purpose of which is to assist the court in determining legal decision-making and parenting time orders in the best interests of the child or children by providing information that's relevant to parental fitness, parties' ability to co-parent, their parties' ability to communicate, or I guess you could say lack thereof, as the case may be. The information is gathered during the conference regarding relevant factors in accordance with the best interests of the children, pursuant to 25-403, 403.3, and .4. So now, in addition to, I'm going to go through some of these aspects, some of the questions, the information that's gathered during a parenting conference in some detail, and I want to say that my goal here is to educate not only on what goes on in a parenting conference, but also provide you information that might be helpful in other respects. For example, if you're assisting a client in some memorandums, in a disclosure statement, in where you're wanting to go over the statutory factors that are important that a judge needs to consider when making legal decision-making parenting time orders that you see kind of outlined in 25-403, that you maybe have a better understanding about what information can kind of go underneath these various headings. And by the way, I'm not saying when I go over some of these things, I'm not saying this is the only way and best way to do things, but this is certainly one way to answer these questions and one approach to gathering information that addresses the questions that are important. So anyways, that's generally speaking, that's what a parenting conference is. The process basically kind of identifies areas of, or through the process, through gathering this information, we identify areas of agreement, significant issues of dispute, and basically what their positions are, what parties' positions are in any disputes. A parenting conference is typically something that is referred, well, it is referred by the judge to be a kind of a lengthy court order, ordering a parenting conference and everything that goes along with that. Now, how do you get one scheduled? Certainly the judge might just do that. You can certainly ask for a parenting conference to be scheduled as well. And just a brief comment, and of course, again, this is kind of my perspective on this, but I think that a parenting conference can be very helpful for in many situations, but certainly in a situation, as I was mentioning before, where parties are self-represented, because there's so much information gathered in these conferences that can be very helpful, very illuminating about what's going on. And again, just areas of disagreement, areas of agreement, what parties' positions are on certain things. And that would become more apparent as I go through some of the questions. It's also important to point out, and I think if you look at the website, on the court website, the website, and again, this is just my perspective, it makes it kind of appear that these are all referrals to outside professionals that conduct these parenting conferences. And there was a time, I don't know how many years this was going on, where I think most of the parenting conferences were referred to mental health professionals that provide those services. But my understanding is that's kind of gone back and forth. And I don't know what the determinative factor always was. It may have been, affordability, or money that the court had to do this in-house. But for many years now, many years meaning at least since I think 2016, that many of the parenting conferences are done through conciliation services. That doesn't mean you can't have an outside professional do the parenting conference assessment. But whoops, what did I do here? I got off the page. But my understanding is that the vast, most of them, as far as I know, are referred to conciliators that work at conciliation services. Just a second. Okay, so that's referrals, providers, costs through the court. I think it's $600, $300 a piece. My understanding is that fee cannot be waived at this time. That's my understanding. Please tell me if I'm wrong, somebody, about that. But that's my understanding. Although you can, I frequently see orders where parties are allowed to make relatively small monthly payments to pay for that service. Also, just so you know, typically it's a 4-hour conference. It's usually scheduled from 8 to 12 on whatever day it's scheduled. Usually those days are either Monday, Tuesday, or Thursday of a particular week that they do parenting conferences. You can have them done at downtown court. I guess this depends where your case are, but they do them through conciliators at downtown, southeast, northeast courthouses, and the surprise courthouse. And just like the other conferences that I've discussed, they're all being done virtually through primarily through Microsoft Teams. Again, obligation participate. Yeah, it's a court order, so you have to participate. If you're a no-show, there's typically a fine. I forget whether it's $100 or $200. I think it's $200 if you're a no-show. And I've already kind of mentioned the benefits as I see them from especially a self-represented litigant for participating. I think it's a great way to get a lot of information in there that you might not, that self-represented litigant might not have the skill or resources to otherwise obtain. When doing when a PC is ordered, there's also an order authorizing the professional or the conciliator to obtain collateral information like DCS reports, police reports, mental health reports regarding the parties. Sometimes child interviews are scheduled at the same time, ordered and scheduled at the same time, which usually occurs right after the parenting conference, although there are times when that is handled differently. Sometimes that will be done by the same conciliator. Sometimes the child interview happens before the conference. It varies a bit. Also, if the conciliator believes that that it would be beneficial to do a child interview, and I'll talk more about child interviews a little bit later, but if the conciliator thinks it would be beneficial to do a child interview, then the conciliator can ask that happen. But I don't know how often that happens when the court doesn't automatically order that. Just make a couple comments about child interviews. Typically, the child, at least for the court to do the child interview, typically the child needs to be around 10 years of age or older. Although certainly, there have been, and I'm sure there'll continue to be, occasion where younger children are interviewed. The issue is whether the child is, sufficiently mature that they can express what their wishes are. The primary purpose of a child interview through the court, it's not a forensic interview. It's, the primary purpose is really to find out what the child's perspective is on, various issues like, what the parenting time schedule should be, or who gets to make the decisions for them. And through that interview, there's other information that's gathered that may or may not be relevant to the situation, about things like relationships between the parties, between parent and child and siblings, other people that are important in the children's lives, that are in the children's lives. Issues having to do with school, mental health, physical health, various things. But it is, again, it's not a forensic interview. It's really conducted in such a way that there's a lot of open-ended questions that are asked, and it's just kind of reporting on what the answers are to those questions. And there's a statute that dictates what the questions should generally consist of, although that can be enlarged. Let's see. I talked about, let's see. So what happens in the conference is, just like all the other conferences, well, it's a little bit different, I guess, in that with the parenting conference, there is a notice of informed consent that is sent to the parties, and the parties review and sign. That gives them a little bit of an outline about what the parenting conference is all about, that it's non-confidential, just important things that the litigants should know going into the conference and participating in the conference. When I meet with people, I talk about basically what I just went over with you, and I'll go over what happens at the end of it. But the primary purpose is, again, really twofold. Number one, to ask and gather information about those statutory questions that the judge needs the answer to help the judge make decisions on legal decision making and parenting time, and then also to see if we can facilitate a partial or a full agreement on legal decision making and parenting time issues. And so that's what happens. Sometimes it becomes very clear early on that either there's going to be a full agreement or there's definitely not going to be any agreement. And so, and so the focus is more on the questions. I would say the questions become maybe a little less important in many situations if there's a full agreement or a substantial agreement. However, the questions need to be asked and answered anyway. And because of, 4 hours may seem like a lot of time, but it goes very fast, and there's a large number of questions. And so, typically, the ground rules are just like everything else, every other type of conference, where only one person speaks at a time, don't interrupt that person, refrain from personal attacks, that kind of stuff. But then the way it's conducted is, we'll ask one parent the first question, they give their answer, ask the other parent the same question, they give their answer, and then the other parent gets the next question first, and so on and so on. So, goes through that process. Typically, the we don't do a lot of back and forth on a particular question because there's just not sufficient time to do that. Although, the conciliator reserves a right to ask follow-up questions and get more information if it seems that it's going to be important to do that. So let's go over now some of these statutory questions, the topics, and discuss a little bit about what information is gathered underneath those topics.
Don?
Yes.
Sorry, there is a comment from Laurentina.
Okay, and the comment is, it's been my experience that the conferences are one-sided, unfortunate and sad, because there is no way to say or do anything to get a different parenting conference provider. So I'm not sure entirely what you mean by one-sided. I'm assuming that you mean that maybe the provider is being a little biased towards one side or the other. If that's what you're meaning, yeah, I mean that's not correct. I mean the party, the providers, are neutrals, and they're there for the purposes that I described. And I would say probably there's certainly a motivation to try to help people come to an agreement. But I appreciate what you're saying. All I can say is that they do their best to, it is a brief assessment, and it's a brief assessment based upon the answers to the question given today, what the conciliator, the provider see at the conference right then and there, and then of course what also based upon the ancillary information or the collateral information that the conciliators have access to, which might include DCS reports, police reports, other reports. But yeah, I'm sorry that you see that. And that's something hopefully that will improve over time from your perspective. But I'll say, you never, just like with mediation, you never know really what you're walking into. I've read what what are situations on paper or on pleadings that are concerning, to say the least. Kind of try. I don't go in with any preconceived notions, but you can't help but think by reading some things that, oh boy, yeah, I don't know that these people are ever going to come to an agreement. And when you get into it, it's completely the opposite. So I've learned over experience to never go in with a biased idea that people are never going to be able to come to an agreement, or that some person really thinks the other person is so awful or not so awful. Maybe that was the case at one time, or maybe just the pleadings were done in a posturing way that weren't really necessarily so genuine. I mean, there can be lots of reasons, or maybe it really is a terrible situation. But more often than not, I'm surprised, pleasantly surprised about how people can work things out, how situations really aren't as bad as they seem to be. But in terms of being biased, we do our best not, to be impartial, and to treat situations as impartial, while at the same time, properly assessing and making recommendations where necessary. And again, I'll talk about that in a couple minutes. But just to kind of go over some of these, some of the questions, the statutory questions that are that information should be gathered for. So this is just kind of a list of some of the questions that you can see. So gathering information on the past, present, and future relationships between the parent and the child or children. So often the information under this, excuse me, will include under this heading, often the